Permission to address the bench collectively as your lordship. Much obliged, your lordship. Your lordships, I'm counsel number 1, appearing on behalf of the applicants. I will be taking up 21 minutes of the court's time, whereas my co-counsel will be taking up 21 minutes, your lordships. I will be dealing with issues 1 and 3, whereas my co-counsel will be dealing with issues 2 and 4, your lordships. If your lordships are satisfied, can I move on to the facts of the case, your lordship? Yes, your lordship. I'll summarize it in 5 sentences. Samrid, your lordship. Much obliged. Your lordship, the facts of the case are as follows. There was a parent company, namely Celebrity Builders India Private Limited, that has been involved in the construction of commercial complexes. It wanted to divulge or transfer all of its holdings to its subsidiaries in many cities, including Bengaluru. Thereby, they created a subsidiary by the name of Bengaluru Celebrity Builders India Private Limited and filed the suitable application for the same in front of the Honorable Tribunal, your lordship. After the application of the tribunal, under unfortunate circumstances, the COVID-19 pandemic hit us, and the effective date was rendered 3 years after the appointed date due to the COVID-19 pandemic and the non-functioning of the courts and court systems, your lordship. In between this appointed and effective period, a piece of land was acquired by the parent company, which they wanted to develop that land into commercial complexes that were to be sold to the prospective buyers, your lordship. The crux of the matter is, when they tried to sell that particular complex, legal opinions were raised by some of the buyers as to who actually has the right to transfer that particular building, your lordship. Therefore, this modification application in front of the Honorable Tribunal. If your lordships are well versed with the facts, can I move on to my issue, your lordship?
Not very well versed, but anyway, we have heard you now.
Yes, your lordship. Apologies for that. Moving on to my issue with regards to maintainability. It is humbly and most respectfully submitted that the Honorable NCLT has exclusive jurisdiction over matters related to company law and insolvency as prescribed by the Companies Act and the IBC, your lordship. Further, it is to note that section 408 of the Companies Act empowers the NCLT to exercise its jurisdiction over matters concerning the Company Act and other laws, your lordship. In furtherance to this, section 430 of the Companies Act, in conjunction with section 63 of the IBC, categorically bars the civil courts from interfering in matters that fall under the purview of the NCLT, your lordships. I am invoking the IBC simply to prove the exclusive jurisdiction of the NCLT, and I won't be using it to further my arguments, your lordship. Additionally, it is also pertinent to note that section 60 clause 1 establishes that the NCLT bench, wherever the corporate debtor's registered office is located, shall have the territorial jurisdiction over matters relating to that particular corporate debtor. In this case, it is Bengaluru, your lordship. With that being said, moving on, in the case of Gujarat Urja Vikas Nigam Limited versus Amit Gupta, the Honorable Supreme Court affirmed that the NCLT's residuary jurisdiction under section 60 clause 5 extends beyond arrangement and insolvency proceedings to encompass all related disputes that fall within its purview, your lordship. This was held by the Honorable Supreme Court. Moving on, in Embassy Property Developments Private Limited versus the state of Karnataka, the Honorable Supreme Court ruled that NCLT possesses jurisdiction over matters involving errors apparent on the face of the record. It was also held that once proceedings have been initiated, all related disputes affecting the corporate debtor's viability must be heard by the NCLT, your lordship. The key words to be noted by means of this judgment is an error apparent on the face of record. So the NCLT has the power to rectify errors apparent on the face of the record. And this also stems from a section, your lordship, section 420 clause 2 of the Companies Act, which empowers the tribunal to amend any order or to rectify mistakes apparent from the record within 2 years from the date of order, your lordship.
Which act you are referring?
The Companies Act of 2013, your lordship. Yes, your lordship. With regards to this particular...
Small question.
Yes, your lordship.
To which error we should call error apparent on the face of the record?
Yes, your lordship. I will be dealing with that. If your lordship permits, can I deal with that now itself, your lordship?
Yeah, just tell us.
Yes,
now
your lordship.
That question has arisen.
Yes, your lordship. With regards to the error apparent on the face of the record, the appointed date in this case was fixed as 1st April 2000.
No, concept of error apparent on the face of the record. Which judgment of the Apex Court decided? Which is the first judgment?
Your Lordship, with regards to that, it is a simple arithmetic or clerical error that can be seen from the face of the judgment. Your Lordship, it's clearly understood that it has to be part of the judgment, and such an error is an error apparent on the face of the record, Your Lordship.
Simple and?
It is a simple and an arithmetical error. Simple.
They would have said like that only.
Yes, Your Lordship.
Legislature, presumption is legislature knows English.
Yes, Your Lordship.
Parliament knows English.
Yes, Your Lordship.
Is it not?
Yes, Your Lordship.
You mean to say Parliament did not know to use your terminology, but it used some other terminology to mean what you have said now?
Your Lordship.
To which we call as error apparent on the face of the record. Means which page? First page of the judgment?
No, Your Lordship. This question of error apparent on the face of the record has been given in certain judgments, Your Lordship, which I will be dealing with in my submissions as well. With regards to that, how is it an error apparent on the face of the record, I will be dealing with now, Your Lordship. Before that, it states that the modification application should be filed within a time period of 2 years, Your Lordship. The effective date, the order passed by the Honorable Tribunal, was 1st of April 2023. Your Lordship. Then the application was filed within 2 years, Your Lordship. It was filed in the month of June of 2024. So there was no delay in terms of filing the modification application. That is number one, Your Lordship. Number two, with regards to the error apparent on face of the record, Your Lordship, it is clear that the parent company always wanted to transfer its assets, liabilities and holdings to the subsidiary. Thereby they moved the NCLT with regards to the application. But after they filed an application, COVID-19 pandemic came, and with regards to that pandemic, court proceedings and court systems were halted for a long period of time, Your Lordship. Thereby, in the fact sheet also this has been given, the NCLT had the opportunity to hear that petition only on 31st of January 2023. And the effective date was passed as 1/4/2023, meaning there is a 3-year delay between appointed and effective, Your Lordship. In such an unprecedented situation, a piece of property was acquired during that 3-year interim period, Your Lordship. With regards to a lack of knowledge by members of the legal fraternity itself as to what to do when there is a 3-year delay between appointed and effective, should any operations not be conducted? If they are conducted, should another application be filed before the perusal of the NCLT? None of that was confirmed. But the intention was clear and the actions justify that intent, Your Lordship. Thereby, it is a simple oversight wherein which that property which was acquired during that 3-year period did not stand transferred as part of the initial assets and liabilities that were transferred. So it is clear and apparent.
Counsel, were you aware at that point in time as a parent company that there was a proceeding pending before NCLT?
Indeed, Your Lordship.
So why didn't you take this caution step of informing the NCLT?
Your Lordship, with regards to that, 2 points, Your Lordship. Firstly, it is given in the fact sheet as well that the courts and the court systems were not functioning during that time. And even if they were functioning, because of the unprecedency of such a situation, there was a lack of knowledge among members of the legal fraternity itself.
So therefore, there is no error on the part of the NCLT's order, right? So you cannot point it on us saying that we have committed the error, therefore that should be effaced.
Indeed not, Your Lordship. That is not what the council is trying to state. They are trying to state that because of such an unprecedented circumstance, there has been an oversight. But that oversight can be accounted to a lack of knowledge with regards to the fact circumstance and... yes.
Counsel,
Yes,
will
Lord.
that not be no mistake apparent on record?
Your Lordship, the mistake that is apparent on record is that assets and liabilities, and the NCLT has also agreed to this because they have passed the effective date. And as on the order passed on the effective date, all assets and liabilities stand transferred from the appointed date, Your Lordship.
Absolutely.
The error apparent is that this particular property was not included in that, Your Lordship.
Was it part of the original application?
No, you're not, Lordship.
Then what is the error which is apparent?
Your Lordship, what council is trying to state is that when that particular application was filed, the asset in question did not even come into existence, Your Lordship. The company had not acquired that asset at that time. It was...
Then why have a modification application at all?
Because, Your Lordship, the property being acquired is in the city of Bengaluru, and all properties in the city of Bengaluru stand to be divulged to the subsidiary, Your Lordship. If this particular property is not considered as part of the original demerger and the original transfer, extra tax with regards to stamp have to be paid, Your Lordship.
So is your scheme of modification only to avoid taxation?
Indeed not, Your Lordship. If that was the case, then that would have been excluded altogether, Your Lordship. And the moment legal opinions were brought to us with regards to who actually owns this property in question, immediately a resolution was passed by the company and the subsidiary. This shows that there is a bona fide intent on our part and there is no attempt to evade tax, Your Lordship. If Your Lordship is satisfied, can I move on with my next?
You can simply enter into a sale deed, right? Is it your case that only through modification that the company will transfer from the parent to the subsidiary?
Your Lordship, it is true that we can enter into a sale deed, but if that is the case, the applicable stamp duty that we have.
So therefore, you are
Yes.
making it obvious that only to circumvent the taxation, you are before us now.
Indeed not, Your Lordship, because if that was the case, then why transfer the initial all of the assets and liabilities in the first place? If that was the case, we can go on acquire properties and then claim to be a demerger and then try to relate it back to the appointed date, Your Lordship.
See, we have one difficulty.
Yes, Your Lordship.
We passed the order based on the applications that were made.
Yes, Your Lordship.
Now, these assets, the appointed date as per you was 1/4/2020.
Yes, Your Lordship.
All these assets have been acquired and sold, etc., after 2021, as per the facts.
Your Lordship.
How does it date back to 1/4/2020?
Your Lordship, that is 2 points with regards to that. One, I will be invoking a particular doctrine, which is my next limb. The first answer to that question is that because it was in the interim period, Your Lordship, the courts weren't functioning. If the effective order was passed within, say, a 2 or 3 month time frame, then all the assets and liabilities would stand transferred to the subsidiary, and the subsidiary can go on and acquire properties. And the main reason the property was acquired was because that land rates were less during the COVID-19 time. So if the effective date, like in normal practice, was close to the appointed date, then the subsidiary could have gone on acquiring the property in the first place and there would have been no confusion, Your Lordship. Because of the unprecedented circumstance, 3-year delay, because of the lack of who has the power to go on acquiring properties, when it stands transferred but the effective order hasn't been passed, there were a lot of questions, Your Lordship. That is the point council is trying to make. And because of those cloudy facts, parent had to acquire it. But parent acquired it with a view to transfer it to its wholly owned subsidiary, Your Lordship. This wholly owned subsidiary is clarified in the proposition clarifications as well. The subsidiary is a wholly owned subsidiary, so there is no intent to actually buy it and then make a transfer to the subsidiary, Your Lordship. If Your Lordship is satisfied, can I move on to my...
No, you need not ask us whether we are satisfied every time.
Apologies,
We
Your
need not tell it at all. Man will be always not satisfied. We judges are also men only.
Apologies, Your
Anyway, but there is one thing we want to make clear. Court can put any question to anyone in the court hall. Court has power to put any question to anyone at any stage of the proceeding in the court hall. Therefore, some questions may go to the audience also. All right. Therefore, when we say something, just note down. Anytime we may ask, we may not be knowing your name, but we have requested the principal, learned principal is also here. She will be able to tell the name and we will ask them to stand up and answer. All right. There is some responsibility. This is not some comedy show. This is a court proceeding. Therefore, everybody has to be serious and everybody has to be prepared to contribute when called for. Yes, all your law students only. Anyway, you are here, except 1 or 2 kids with a claim equal to law students. Therefore, they are here. All right. One question we have asked, just verify, we will tell also. First decision of the Apex Court on error apparent on the face of the record is Hari Vishnu Kamat judgment. I think 1950, 51, something like that, where they answer what is error. And you did not answer my brother's question. Why are you attributing error to us?
Your Lordship, again to clarify that particular question, I am not, council is not trying to attribute the error to the NCLT. The council has simply filed a modification before the NCLT because of an oversight by the applicants. That is clear, Your Lordship. They are not trying to shift the onus on the NCLT, Your Lordship. But that oversight, as I have answered another Lordship's question, is because of the fact circumstance, Your Lordship. Moving on, in the case of Gujarat Urja Vikas Nigam case, the Supreme Court once again reiterated that the NCLT's jurisdiction includes all matter critical to the CD's survival, including disputes arising post-admission of the proceedings, Your Lordship. This was held by the Honorable Supreme Court. Not to mention the Bankruptcy Law Reforms Committee that laid the foundation for the IBC as well, has vested far-reaching powers to the NCLT to actually adjudicate on matters relating to company, insolvency and any matter arising post-admission of the issue itself, Your Lordship. Moving on, with regards to the doctrine I said I would invoke, Your Lordship's council would like to invoke the doctrine of relation back, Your Lordship. This doctrine posits that once a scheme is sanctioned, its effect dates back to a specific date, commonly referred to as the appointed date, Your Lordship. That I have proven again as well. From the appointed date, the assets and liabilities stand transferred. But because of the delay, we claim, the council seeks to move the NCLT so that this particular property acquired during the interim period can also fall part of that, so as to avail the rightful benefits that the applicants are deemed to avail, Your Lordship.
Can I ask one question?
Yes, Your Lordship.
Little out of syllabus.
Yes, Your Lordship.
Can you say, quote, any other law where doctrine of relation back is invoked?
Your Lordship, can I take 10 seconds to think about it?
Huh?
Can I take 10 seconds to think?
For thinking?
Yeah.
All right. But phone a friend is not available. Yes. Anybody from the audience? Correct. Suppose if a widow adopts, it relates back to the date of the demise of her husband. Okay. Doctrine of relation back. Alright?
Yes, Your Lordship.
Very good answer.
Noted, Your Lordship.
Ah.
Finally, in the case of Santosh Vasantrao Walokar and others versus Vijay Kumar Iyer, the Honorable NCLAT categorically held the same thing which I have cited in my previous judgments, which is that NCLT has the power to admit proceeding matters that are post proceedings. However, it is limited to an error apparent on the face of the record, which counsel has tried to prove based on the fact, circumstance and other issues.
All right. Now
Yes.
you say
Yes, Your Lordship.
the you quoted which decision?
Your Lordship, Santosh Vasantrao Walokar and others versus
Decision by
the NCLAT, Your Lordship.
NCLAT.
Yes, Your Lordship.
Which law says NCLAT's decision will be binding upon this tribunal? Like there is Article 141, decision of Supreme Court binds all high courts.
Yes,
There
Your
are Article 227, read with 215. The high court judgments with all other courts below.
Yes, Your Lordship.
Which law says that this tribunal is bound by that decision?
Your Lordship, with regards to that, firstly, counsel is not trying to prove that counsel is bound by the decision. Secondly, because it is an appellate tribunal, Your Lordship. It is an appellate tribunal, and under the IBC, which counsel is not particularly sure, but under the IBC, which creates the under the IBC and company laws that create the NCLT in the first place, NCLAT being an appellate tribunal,
Counsel,
a higher, yes, Your Lordship.
You mean to say that because our order will be appealed before the NCLAT, we should also be thinking in the same line? Is that what you're trying to say?
No, Your Lordship. If that is what counsel would contend, then the application could have been filed before the NCLAT itself. It is an error apparent on the face of record. NCLT has all powers to hear this matter, and that's why the application has been filed before the Honorable NCLT, Your Lordship.
So you mean to say there's no provision or a law which specifically says that the subordinate court will have to necessarily follow the order of the appellate court? Is it because of judicial discipline, or what would be an answer to that? Is it because of some discipline, or is it because of some statutory
Is it
requirement?
doctrine of precedent or doctrine of some discipline?
Your Lordship, counsel
Doctrine
pleads,
against inconsistency.
Your Lordship,
Whether Munsif is bound by the decision of district judge? To clarify
Yes,
our
sir.
question, we are asking one more question to you. Whether Munsif is bound by the decision of the district judge?
Your Lordship, it is the higher.
If you know, you say, I know.
Yes, sir.
Otherwise, you can. Many things will not be known to us at all. Is it? Socrates said, I do not know.
Lordship,
Therefore, don't hesitate to say no if you do not know.
Your Lordship, no, Your Lordship, Munsif is not bound. Because it is the constitutional courts that set a precedent, Your Lordship. The above
Right
mentioned.
answer.
Yes. Lordship, if Your Lordships may, can I move on to my third issue with regards to GST? Much obliged, Your Lordship. Your Lordships, it is humbly submitted that the transfer of an undertaking by way of a demerger does not attract GST as it qualifies as a transfer of a going concern, and this is covered under the exemption granted by serial number 2 of notification number 12 of the year 2017, and it is dated 28/6/2017, Your Lordship. This has been granted under section 11 clause 1 of the CGST.
Okay.
Moreover, yes, Your Lordship.
You're talking of an exemption.
Yes, Your Lordship.
Supposing the exemption were not there,
Yes, Your Lordship.
would it be taxable?
Indeed not, Your Lordship. Because for levying GST, there has to be a supply under section 7 of the CGST Act, and there has to be consideration, Your Lordship. Even if there is not consideration, Schedule 1 and Schedule 2 of the CGST Act speaks about transfers that can be taxed even when there is not a consideration, Your Lordship. But those schedules talk about a permanent transfer of an asset or a group of assets, not permanent transfer of a business as a whole, Your Lordship. And this classification has been held by the Honorable High Court of Kerala and certain other high courts as well, Your Lordship. I can quote the judgment with regards to this particular distinction. In the case of Zakaria versus State of Kerala, the Honorable High Court clarified that a transfer of business does not amount to a mere sale of assets, and where a business is transferred as a whole, it cannot be considered as a taxable supply, Your Lordship. This is where I would like to make a distinction between, yes, even if there is no consideration, under certain cases mentioned in the CGST Act, GST can be levied. But in this case, it cannot. Your Lordship, Council seeks an extension of 2 minutes, Your Lordship.
Yes.
But in this case, it cannot be levied because it is a transfer of a business as a whole, Your Lordship. Moreover, in the case of the Honorable High Court of Madras.
Is it goods or is it services?
Your Lordship.
Is it goods or is it services?
Your Lordship, that depends, Your Lordship, because with regards to the ready to sell units, that can be classified as a good in the proposition. With regards to the units that are constructed based on the whims and fancies of the customer, they are customizing those particular commercial complexes. That is considered as a service, Your Lordship.
This we are dealing with completed flats and incompleted flats.
Indeed, Your Lordship.
Is that goods?
Your Lordship, the incompleted flats that are built based on the requirements of the customer, Your Lordship, that is considered as a service, Your Lordship. Whereas the one that are ready to sell is not considered a service, Your Lordship.
Is it considered as goods?
Yes, Your Lordship.
You're sure?
Yes, Your Lordship.
What is the difference between movable and immobile property in General
Your Lordship,
Clauses Act?
apologies, it is a immovable property in this case. Apologies, Your Lordship.
It's okay, it's okay.
The Honorable High Court in Monsanto Chemicals of India Private Limited, the High Court of Madras.
You have to be very careful in life when you are saying yes. Not necessarily marriage.
Yes, Your Lordship.
Construction itself is service.
Yes, Your Lordship. Construction, sir. In fact, the parent company was registered under that in the previous VAT regime also, Your Lordship. In this particular case, Your Lordship. Yes, Your Lordship.
Entire thing, is it a plan of avoidance or tax avoidance or tax planning? Or what is the plan?
Your Lordship, firstly, I would like to reiterate that it is not a case of tax evasion at all. It is none of that sort. Actually, my co-counsel will be dealing with that issue extensively. But with regards to your question, no, sir, it is not. Because like I've already mentioned, it is the particular property acquired should be treated as part of the initial demerger, Your Lordship. That is the point I'm trying to make, number one. Number two is that there is no question of a supply in this case. Your Lordship, 1 minute extension. There is no supply, there is no consideration, Your Lordship. It is rightful that there is an exemption of GST under this case, Your Lordship.
See, the property was procured in that interregnum period,
Yes, Your Lordship.
and parent company was very much aware of it. Was
Yeah.
it not? Parent company was aware of it.
Yes, Your Lordship.
Still, it was not bought before the NCLT.
Your Lordship.
And now, having realized that as a going concern, you have the advantage because of the exemption as a going concern, you are trying to avoid. Is it so?
Indeed not, Your Lordship, because firstly, like I already stated, the courts weren't functioning at that time, number one. Number two, a resolution was passed immediately when certain legal ramifications were brought to the notice of the parent company. And thirdly, Your Lordship, in the prop, it is given that some of these buyers got legal opinions with regards to who can actually transfer the property, Your Lordship. For a case of arguendo, for all possibility, the company could have found other buyers who did not have any such legal impediments, Your Lordship. But they chose to abide by the law and they chose to file a modification application so that it is dated back to the initial order, Your Lordship. That was given by the Honorable NCLT.
Let us see what your partner will say.
Yes, Your Lordship. I'll conclude with that, Your Lordship.
You are the counsel.
Indeed, Your
Lordship. This is council number 2, and before that, can I seek your Lordship's permission to collectively address?
Why permission? There is a Advocates Act which gives right to argue. Suppose if we say we will not permit you, will you go home?
Your Lordship, I was seeking permission to collectively address the bench as your Lordship, Your Lordship. Much obliged, Your Lordship. This is council number 2, representing the applicants in the case of BCBIPL versus CBI.
Your client will ask back the fee. You have not argued to give that fee back.
Your Lordship. Your Lordship. In the case of BCBIPL versus CBIPL and others, I shall be dealing with issues number 2 and 4, and for this. Indeed, Your Lordship. Issue number 2 talks about stamps duty, and issue number 4 talks about whether income tax and capital gains tax are applicable or not, Your Lordship. Much obliged. With that, I will be moving on to issue number 2, which talks about stamps duty. So, in this current case at hand, is there a stamps duty that can be attracted to the transaction as an independent and distinct transfer or conveyance, or does it attract according to a demerger scheme, is the question that's posed before the bench, Your Lordship. And I shall be dealing in a 3-pronged fashion as to how this falls under the demerger scheme itself, and for the purpose I will be using 3 primary statutes, Your Lordship. 1, the Companies Act 2013 and Income Tax Act, and then also thirdly, I will also be using the Karnataka Stamps Duty Act 1956, Your Lordship.
Stamp Duty Act?
Sorry, Your Lordship.
Is it Stamp Duty Act?
Karnataka Stamps Act, Your Lordship. My apologies, Your Lordship.
1957.
1957, much obliged, Your Lordship. With that, I will move on to my first submission, Your Lordship, to clear something, to clear the air out and to inform the court about our intention. This is clearly not a tax evasion scheme, Your Lordship, as much as it is a tax planning, Your Lordship. We are clearly seeking and using only exemptions and reliefs that are there according to the laws, and I shall be advancing them in my further submissions. However, this is not tax evasion as much as it is tax planning, Your Lordship. That is one. And I shall also be drawing out or culling out a few facts from the fact sheet itself to clear the air out and to make a few facts that are undisputed brought before the court's attention, Your Lordship. First, Your Lordship, this case or this property in question was acquired during a period where there was COVID-19 and lockdown was imposed, Your Lordship. This is an unprecedented situation in itself. There is no other situation which came that is close to this effect, or say for example the courts came to a grinding halt. Any other institution or organizations that were also working came to a grinding halt. So this was an unprecedented situation in itself. So there is no way the applicants could have foreseen that, Your Lordship. There is no possibility for us to have reasonably foreseen that possibility to have come, and because of that we are planning a tax evasion. So that is ruled out, Your Lordship. Secondly, Your Lordship, this property itself was not available until January 2021. This property was available only in the year January 2021, and that's when it was acquired. Before that there was no possibility for us to acquire. And all the properties that were actually acquired before the demerger, for all of that demerger and stamps duty and income tax that are applicable to that particular demerger have already been paid, Your Lordship. This is not a case of tax evasion, hence once again stated, Your Lordship. Thirdly, Your Lordship, my third submission would be that this is a wholly owned subsidiary company, Your Lordship, meaning 100% of the share is wholly owned by the parent company in exchange for the demerger that has happened to the subsidiary company or resulting company, Your Lordship. And for those reasons, whatever transaction or whatever transfer happens, that happens as part of an internal restructuring between the parent company and subsidiary company or resulting company itself. And
Brother, so, which is that judgment of House of Lords which said company is independent of its shareholders?
Your Lordship, there is no particular judgment that I would like to bring up right now.
Why do you say like that? You may say, I do not know.
Your Lordship, the council
Judges may know sometimes.
Indeed, Your Lordship. The council at the moment does not have a case law.
Is it not Solomon versus Solomon and Company?
Indeed, Your Lordship.
Is it not?
Council is not there, but I will take it into consideration.
Proceeding from that now.
Indeed,
That's
Your
the
Lordship.
bedrock for our question now.
Indeed, Your Lordship.
You may be, at least there are 2 companies.
Indeed, Your Lordship.
They are so registered.
Indeed, Your Lordship.
There are 2 entities, legal persons.
Indeed, Your Lordship.
Is it not?
Indeed, Your Lordship.
Then how is this argument that this is a holding company, that is a held company, subsidiary company, therefore transaction is same? How will it not offend the principle of personality of the companies, legal personality of the companies?
Indeed, Your Lordship. I would like to answer the
With
question.
summoned in chapter person,
Indeed.
12th edition, Fitzgerald's
Indeed,
edition.
Your Lordship.
There is a separate chapter
Indeed, Your
on
Lordship.
persons.
Indeed, Your
So
Lordship.
will
The
it
council
not
would like
offend
to
them?
Indeed, Your Lordship. The Council would like to answer the question in a two-pronged fashion, Your Lordship. One, like I already stated, Your Lordship, this is a wholly owned subsidiary company, meaning it totally belongs, or the board of directors totally sit in the parent company itself, Your Lordship. So the stake, 100% of the stake is with the parent company, one, Your Lordship. Two, as on the date of the appointed date, the transactions or the transfer of assets and liabilities from the parent company to the subsidiary company was not carried out according to the fact sheet itself, Your Lordship. As on appointed date, not all the assets and liabilities were transferred. Only when the effective date came into play, entire assets and liabilities were transferred from parent company to subsidiary company, Your Lordship. If Your Lordship is satisfied with the answer.
Please do not ask that question.
My
No man
apologies.
is ever satisfied.
Apologies,
Okay?
Your Lordship. Apologies.
We want to know more. Yes.
Indeed. Indeed,
Typically,
Your Lordship.
council, just to understand, see, when you typically file an application before NCLT for demerger, you list the assets,
Indeed.
right? That may be subsequently it may be sanctioned by the NCLT.
Indeed, Your Lordship.
But when they sanction it, they give a back date, saying that the appointed date is as of 1/4/2020, which means that only those assets which were up to 1/4/2020 will be transferred as per the scheme. So are you trying to stretch the meaning that anything which comes in between the effective, or rather the appointed date and the effective date, and because of this delay, unexpected delay that you are saying, that anything purchased in between also will get automatically attracted into that scheme?
Indeed not, Your Lordship. Like Your Lordship already mentioned, between the appointed date and effective date only, this property in question was actually purchased. That is an established fact, Your Lordship. However, also like the Lordship already mentioned, it is backdated to the appointed date, that from that point on, whatever
Of the assets which you had originally filed.
Indeed,
So
Your
you
Lordship.
started by filing an application.
Indeed.
You list the assets.
Indeed, Your
Though the order is passed subsequently, it says it's deemed that these assets are transferred from 1/4/2020. We are not dealing with any subsequent transfers.
Indeed, Your Lordship.
So how would you say that because there was a delay in passing this order, and because the appointed date and the effective date is later, that anything which is purchased in between all the transactions will be attracted? What we
Indeed.
actually meant was only those assets which stood as of 1/4/2020.
Indeed, Your Lordship, that is exactly what the council is also trying to contend. All the properties that were enlisted while the application was filed before the appointed date is the only property that is in question. However, that is what we are also here for, seeking a modification to the application to include this property into the demerger scheme. And that's the whole reason why we are contending, and as to why this falls under the demerger scheme, Your Lordship.
Is this not a standalone transaction? Now, we were with you when we sanctioned the scheme, because as you cited, it's a going concern basis. This is from parent to the subsidiary. We were with you. We sanctioned it. But when you try to, on piecemeal basis, to transfer the properties, we are prima facie not with you, because this is a standalone transaction. You have another way of transferring the property to the subsidiary by way entering into a simple deed of conveyance.
Indeed.
So I think that tax seems to drive this entire transaction or this application. That's what our prima facie view is.
Indeed not, Your Lordship. Although this transaction on the surface seems like a standalone and isolated transfer, this property was always intended to go to the subsidiary company only, Your Lordship. When in the year of 2020 itself, when the parent company decided to form a subsidiary, not only in the city of Bangalore, but subsequently in other cities as well, it was decided only to consolidate all the assets and liabilities separately and distinctively for all the other undertakings, Your Lordship. This was the intention of the parent company. Subsequently, when this property was purchased, the intention, the substance over the form was to give this company to the subsidiary company when it comes into total legal existence, Your Lordship. And for those reasons, this has to be attributed, and that's what we request, that this has to be attributed under the demerger scheme, Your Lordship. Much obliged, Your Lordship. With that, I would like to move on to the first prong, Your Lordship, which is the demerger, the definition of demerger under IT Act, under the IT Act, Your Lordship. 2 Clause 19AA talks about the definition of demerger, and there are 4 conditions that demerger lays down, and out of two of which are crucial for the current case at hand, and I will go on to prove as to why these 2 conditions are fulfilled on our side as the applicants, and hence this transaction falls under demerger, Your Lordship. 1. All the property of the undertaking being transferred by the demerged company immediately before the demerger becomes the property of the resulting company by virtue of demerger, Your Lordship. 2, Your Lordship, the resulting company issues, in consideration of the demerger, its shares to the shareholders of the demerged company on a proportionate basis, Your Lordship. In the clarification to the proposition, Your Lordship, it was clearly stated that the shareholders of the parent company got share, which is 100% wholly owned subsidiary, got share in return to the demerger that was carried out, Your Lordship. So these two conditions stand fulfilled, and hence this is a demerger under 2 clause 19AA of the Income Tax Act, Your Lordship. And if I had to move on to the next statute, Your Lordship, which is the Karnataka Stamps Act, Your Lordship. And before that, I would like to clarify that any stamps duty that is attracted on any transfer is done solely based on whether that is an instrument and not whether it's a transaction, Your Lordship. Only a stamp duty can be attracted only if there is an instrument to that effect. Otherwise, only solely based on a transaction, a stamp duty cannot be attracted, Your Lordship. And with regards to that, we have various judgments in various other high courts and one Supreme Court judgment in the case of Hindustan Lever Limited also, where it was clearly stated both in Indian Stamps Act and various other Stamps Act like Bombay Stamps Act and Calcutta Stamps Act, where the section 2 of the definition part defines as to what conveyance and instruments are. And with that effect, there is also the definition of instrument and conveyance under 2 clause D and 2 clause J of the Karnataka Stamps Act, Your Lordship. This demerger order falls under the instrument or conveyance under this ambit, Your Lordship, and hence only a 3% tax, 3% stamps duty has to be paid, and as opposed to 5% plus 1% as the respondents might come and contend, Your Lordship. 3% is paid because on a demerger scheme or on a demerger order, only 3% is paid as opposed to 5% plus 1% on a normal transfer or on a normal conveyance or a normal sale. In this case, since there are 50 properties in question and 3 crores per property, there is a total amount of 150 crores in question. And hence, we would be paying 4.5 crores as opposed to 7.5 plus 1.5 crores, which is a total of whooping 9 crores, Your Lordship. Then we would be paying a double tax, Your Lordship. We have already fulfilled our requirement of paying 4.5 crores according to the demerger order, Your Lordship. That is one submission with regards to Stamps Duty Act, Your Lordship.
One
question, Your Lordship.
You said there is Indian Stamp Act. Is it not? Indian Stamp Act is enacted by whom?
The legislation, Your Lordship.
Which legislature?
It was done in the colonial period, but it was ratified when the constitution came into effect.
So it is attributable to which body?
The legislature.
Which is that legislature?
Parliament, Your Lordship.
Parliament. If Indian Stamp Act is the law relating to stamp duty, the Karnataka Stamp Act, in which list Karnataka Stamp Act is enacted?
State list, Your Lordship.
State list?
Stamps on property and on transfers comes under the stamps state list, Your Lordship. And in the Indian Stamps Act itself, it's mentioned that the Indian Stamps Act can be embodied entirely in its entirety by few states, or it can be modified and then in each individual state can make their own Stamps Act, and that's how Karnataka Stamps Act was
which entry in the Constitution? Please give Constitution.
Your Lordship, I don't have the entry.
Anybody in the audience? Give Indian Constitution, Court of Sirs. Give a Constitution. Anyway, just keep it.
Indeed,
okay?
Your Lordship. Indeed.
We'll come back to that one. Number one. What is difference between the tax and license fee?
Indeed, Your Lordship.
Which judgment?
Your Lordship, the council currently does not have a judgment on their hand, and plus license fee is not something that is dealt with, but however I'll try to the best of my capability to answer the question. Can you repeat your question, Your Lordship? The difference between license fee and taxation, is it? Taxation is one similarity is, Your Lordship, license fee and taxation is something that the government takes from the people who carry out transactions, Your Lordship.
Why your college will not take a fee from you?
Your Lordship, that is not a license.
Necessarily government.
Your Lordship, like you already said, a college can be a government institution or a private institution, but it does not collect a license fee.
No, we are asking you, tax and fee, difference between, forget license.
Indeed, Your Lordship. Indeed.
Tax as distinguished from fee.
Indeed, Your Lordship. Tax is something that is given as an obligation, Your Lordship. Fee is something that is given in return of a service or a good that is produced, Your Lordship.
You put it beautifully.
Much obliged, Your Lordship. If I may proceed with the case law, Your Lordship, in a case called In Re Government Agro Farms, which is also mentioned in the compendium flag post number 5, Your Lordship, it clearly states that a scheme of amalgamation, where there is a scheme of amalgamation to streamline affairs of companies, it cannot be denied only on the ground that one of the reasons for the proposed amalgamation was to reduce tax liability, Your Lordship. However, if its sole purpose is to evade tax, then it becomes a problem. But for the sake of an arguendo, even if we were to assume but not accept to anything that yes, there might have been a small possibility that this modification scheme is for the purpose of tax planning, it has followed all conditions or essentials, and the transfer is done in good faith and with bona fide intention, Your Lordship. Like the council already mentioned, one, it fulfills demerger, it fulfills the definition of demerger under Income Tax Act, Your Lordship, and secondly, to go on and enlist a few conditions under the Companies Act, Your Lordship. Section 230 to 232 talks about a few conditions, Your Lordship. One, it is to produce a few draft scheme of arrangement, and then it has to be passed by a board of directors, and then a resolution must be passed. After that, this has to be brought to the kind attention of the tribunal, honorable tribunal, Your Lordship. Further, after that, like we already mentioned, this is a wholly owned subsidiary company. All of these conditions or essentials have been fulfilled according to section 230 to 232 of the Companies Act 2013. So one, income tax and all the essentials that are laid down under the income tax are fulfilled. Two, Companies Act also fulfilled and further expounded by the case law that I just mentioned, Your Lordship. That condition is also fulfilled. Hence, this is not tax evasion as much as it is tax planning, Your Lordship, which is something a relief or exemption in nature that can be sought according to the books by the applicants, Your Lordship. And
you can take assistance of your friend for finding out that article, entry, schedule 7, list. Okay.
Counsel, one question.
Indeed, Your Lordship.
Assuming that we do not approve of the modification application, what will be the income tax implication as per you on this transaction?
Indeed, Your Lordship. I will be dealing with the income tax limb separately, but for the sake of answering this question, Your Lordship, under 47(6)(b) and 47(6)(d), Your Lordship, of the Income Tax Act itself, if there is a demerger, there is no tax liability for the company that is resulting or subsidiary company, Your Lordship. But however, if this transaction is to be qualified as a distinct and independent transfer that is considered in isolation, then just for the purpose of this question, Your Lordship, yes, there would be a capital gains tax that would have to be paid to the parent company, Your Lordship.
When is a capital gains tax payable?
A capital gains tax is payable, Your Lordship, if in this case, say for example, the parent company is transferring the property to a subsidiary company because it is gaining something out of that, and
Is it any property?
Your Lordship, immovable property in this case. Your
No,
Lordship.
I'm asking you. You said transfer of a property. Is it any property?
Your Lordship, income tax is not applicable to movable properties, it's applicable only to immovable properties.
Transfer on capital gains will arise if it's a capital asset.
Indeed, Your Lordship.
Correct.
Indeed.
Now, as far as your holding company is concerned, these flats are a stock in trade,
Indeed, Your Lordship.
or is it capital asset?
Your Lordship, this is a stock in trade, Your Lordship.
How will capital taxation come here at all?
Your Lordship, 50 units out of, so 25 units out of the total 50 units, Your Lordship, are constructed units, Your Lordship, and the other 25 are work in progress, Your Lordship. But for the purpose of us considering this whole complex, we are considering this whole complex as work in progress, Your Lordship. But otherwise, if we were to consider this as a distinct transfer, for those 25, only to the extent of those 25 units, a capital gains tax might be attracted.
No, I am asking you this question again. Is it classified as stock in trade, or is it classified as a capital asset?
Right now, in the current case, it's classified as stock in trade, Your Lordship.
Will capital gains transaction come in at all?
Your
That's
Lordship,
the question.
Indeed, Your Lordship, that is one of our contentions as well. Since this is stock in trade,
No, that's a contention that flowed from what I told you.
Your Lordship, I was going to deal with the issue subsequently. Since I'm dealing with only stamps duty right now, I was leaving it for later, Your Lordship. Much obliged, Your Lordship. If you want me to deal with income tax, I can go on to the next issue, Your Lordship, and I will answer your question as well, Your Lordship. Like Your Lordship already mentioned, yes, this is stock in trade, Your Lordship, and hence this does not qualify as a capital asset. And according to section 47, clause 6 and clause 6b and clause 6d, a capital gains tax would be attracted. But in the current case, since this is only a stock in trade, the capital gains tax would not be would not be attracted, and that is
But
one of our submissions, Your Lordship.
I think
Indeed.
you're taking the lead from the learned brother judge, because you started saying section 47.
Your Lordship.
47 deals only with capital gains exemption.
I have 41 clause 1 as well.
But which one are you finally referring to?
Your Lordship, I am referring to both, Your Lordship. I am reading 47
Can-
read with
therefore,
40.
therefore, can an asset be both capital asset as well as stock in trade?
Your Lordship.
What's the difference, counsel, between a capital asset and a stock in trade
Your
in
Lordship.
your situation?
Indeed, Your Lordship. Speaking from an accounting point of view, Your Lordship, stock in trade basically means an asset that is carried over or spilled over from one balance sheet to the other balance sheet year by year, financial year wise, Your Lordship, year by year. It goes on to the subsequent years until and unless that capital is, construction is finished, Your Lordship. In this case, since the construction of the complex is not completely finished, this is considered as stock in trade, Your Lordship.
Apart from your novel definition of stock in trade is something which is an inventory, right? Which is your business asset,
Indeed, Your
out
Lordship.
of which you make money. You do not, for the purpose of investment, you do that. You do it for the purpose of transferring, sell it to your customers.
Indeed, Your
So
Lordship.
that, as rightly pointed out, this would ideally fall in the definition of a stock in trade or an inventory,
Indeed, Your Lordship.
which is not tax free. It will attract a higher rate of tax of 30%.
Indeed, Your Lordship.
So you are not completely wriggled out of this. Therefore, it is a stock in trade. It is not taxable. Cannot be an argument. You will be taxable automatically at a higher rate of 30%.
Indeed, Your Lordship, but however, under 47 clause 6b and d, which I shall be referring to, there is no tax on a demerger or property that has been transferred under demerger, Your
Only
Lordship.
to clarify, you cannot rely on 47 moment you say it is actually stock in trade, because you fall into a different chapter. You
Or
fall into
exclusive.
exclusive, exactly.
Mutually
We
exclusive.
have different heads of taxation, income taxation.
Indeed.
Capital gains is one type of income and business income is other type of income. You cannot rely on 47 when you're dealing with a taxation under section 28, which is for business income. That's what the learned judge wanted to point it out.
Indeed, Your Lordship, the council does understand, since this is a company that primarily deals with construction, its stock becomes the building itself, as opposed to an investment that any other individual entity or individual person might make. That becomes an asset, capital asset. But in this case, it is a stock in trade, and
If it is a stock in trade, all your arguments on capital asset will go.
Your Lordship, that is an arguendo, Your Lordship. If this was supposed to be considered as a capital gains, even then the arguments of the respondents falls defeated. But our primary contention is, yes, this is stock in trade. But in arguendo, not accepting to anything, but just assuming whether it was capital gains, capital asset, in that case, what would happen? That is what our contention would substantially subsequently go into, Your Lordship.
If we can classify the assets into three types. We have land here, we have completed building here, we have work in progress.
Indeed, Your Lordship.
Which is a capital asset, which is a stock in trade? Could you please
Indeed, Your Lordship.
identify?
The completed construction and the land would be capital assets, Your Lordship. Work in progress is stock in trade, Your Lordship. If Your Lordship is fine. Yeah, much obliged, Your Lordship. Your Lordship, the first submission would be that there is no separate transfer or consideration resulting as a result of that transfer of. The council seeks an extension of 2 minutes, Your Lordship.
2 more minutes. All.
A minute, Your Lordship.
Ah,
Much obliged. Your Lordship, there is no any.
Which is that judgment of the apex court which said for every case the time should be prescribed by the court? Anybody from the audience? Escorts India Limited versus LIC of India, 86 Supreme Court,
Okay.
1986, Justice O. Chinnappa Reddy's judgment, which said court has to prescribe time. Anyway, you have asked for
Indeed,
some
Lord.
time, some relaxation, all
Much
right. But don't think that the wall, there is a clock also. You have to see that also,
Indeed, Your Lordship.
all right?
Indeed. Much
Or
obliged, Your
at least
Lordship.
calendar you can see, if not the clock.
Indeed, Your Lordship. And for the sake of arguendo, I'll wrap my arguments up very quickly, Your Lordship. For the sake of an arguendo, if this was supposed to be considered as a capital asset, even in that case, this falls defeated squarely through two provisions of the Income Tax Act, one 47(6)(b), 47(6)(d), Your Lordship. 47(6)(b) gives a blanket exemption to a subsidiary company or a resulting company because it got a transfer through the demerger scheme or the order that was passed by the NCLT, Your Lordship. One. Subsequently, 47(6)(d) talks about if there is any consideration that is given in return to the demerger, again there is no tax that is attracted in this case, Your Lordship. Both of these provisions are fulfilled, and hence even in the sake for an arguendo, capital tax tax is not attracted, Your Lordship. Do I answer the
That
question?
demerger scheme you said,
Indeed, Your Lordship.
can it be considered as an instrument for the purpose of stamp duty?
Indeed, Your Lordship. Like the Council already mentioned, in the case of Hindustan Lever Limited through a Supreme Court Apex Court decision, and subsequently in the Delhi NGCT case, in the Lee Taka Pharmaceuticals case in the Maharashtra High Court, in several other High Courts cases, it has defined and interpreted their own state's stamp duty, Your Lordship, Stamp Act, Your Lordship, and through all of that, one thing is clear, Your Lordship, through the definition under Section 2, and in this case Section 2D and J, it clearly defines that conveyance and instruments and any order that is passed by NCLT falls as an instrument, and subsequently, since this is an instrument, it shall also be considered as a conveyance, and for that purpose only 3% tax can be paid as opposed to 5% plus 1%.
Are you sure, Council, is it 3%?
Your Lordship, indeed, Your Lordship, it is 3%, Your Lordship. Much obliged. With that, Your Lordship, can I move on to the last submission, Your Lordship? Under 53A of the Transfer of Property Act, Your Lordship, the respondents might come and contend that yes, there was a possession that was transferred to the applicants, Your Lordship.
Part performance.
Part performance, Your Lordship, 53A. But this is not deemed transfer, Your Lordship, primarily because of two reasons that can be read from the fact sheet itself. This can be culled out from the fact sheet itself, Your Lordship. The sole intention was to
How there can be part performance?
Your Lordship, in this case, Your Lordship, management and construction of the company is done by the subsidiary company, Your Lordship.
Correct.
So this is past performance in exchange of the transfer being completed from the parent company to subsidiary company.
With whom the possession lies?
Possession lies with the subsidiary company, Your Lordship.
And how part performance is attractive?
What is 53A, Council? Just to be clear on the principal law.
Indeed,
What
Your
is Section 53 of which Act?
Your Lordship, 53A of the Transfer of Property Act talks about part performance, Your
What is
Lordship.
part performance, Council?
Part performance, in principle, it means if there is possession, it is deemed to have transferred, Your Lordship. That is
Tenant.
what.
So can we also from whom? So will it also attract a tenant having possession from the landlord? Is it a part performance?
Your Lordship, tenant falls under a lease agreement, Your Lordship, but this is
So
not.
what is contemplated? In 53A, possession is granted in contemplation of what? For what purpose it is given?
Your Lordship, it is done in exchange of part performance, Your Lordship.
No, it is.
The question is not that. What
No,
my brother is
when-
asking.
Yes.
And you may be in possession as a tenant, as a usufructuary mortgage, as a licensee. But part performance possession has to be in furtherance of an agreement to sell, where the seller, the buyer has already performed his part, but seller has to. Is it not? But here possession is with whom? With you.
Indeed, Your Lordship.
Then where is the question of part performance?
Your Lordship, this falls under part performance because subsequently the intention is for the property to go back to the subsidiary company, Your Lordship.
We are trying to rescue you, saying that there is no part performance.
Your Lordship, indeed, Your Lordship, I am just interpreting 53.
Whether your client has not paid the fees to you.
Your Lordship, I am primarily interpreting 53A, but I am contending against 53A only, Your Lordship.
But otherwise, Council, it may not fall under 247 clause 5. But has the parent company not extinguished or rather relinquished its right over these assets? Will it still not attract a transfer?
In that case, it would, Your Lordship, but according to the fact sheet, Your Lordship, the effective date came in a later part in the year of 2023, Your Lordship. Till on or before the appointed date was passed, no assets or liabilities were completely transferred from parent company to subsidiary company, Your Lordship. That is the answer to that
Is
question.
there, from a stamp duty point of view also, I'm just asking you this question.
Indeed, Your Lordship.
Supposing, is there an instrument which evidences this transfer?
Your Lordship, with respect to 53A, Your Lordship.
Yes.
Your Lordship, the Council is not aware of that.
No, it
particular
has to be in
provision.
writing. Section 53A says it must be an instrument in writing, a document in writing.
In the
Agreement,
Supreme
have
Court,
you
Justice of Giridhar was also mentioned. Your
Please
Lordship, if
see
I'm
the
not wrong.
decision in Balbir Singh Maini's case.
Indeed, Your Lordship.
For your knowledge.
Indeed, Your Lordship. With that,
Council, just to clarify, agreement to sell, parting away with possession is called as part performance.
Correct.
Indeed, Your Lordship. Much obliged. With that, can the Council move on to the prayer, Your Lordship?
Prayer we know. Now only we pray that you permit others to argue. Yes.
It was a
The
pleasure.
court is making prayer to the litigant now.
Indeed, Your Lordship.
All right. You did well.
It was
You
a pleasure
answered
arguing
well.
with you.
Yes, yes.
Thank you.
Let us see.
Omkar Patnaik, Honorable Bench. May the Council refer to the bench collectively as your Lordships and individually as your Lordship. Much obliged to your Lordship.
Yes.
If the bench may please, may the Council summarize the facts of the case in a succinct manner.
Yes.
Your Lordship, the applicant in the given case is a real estate company, a wholly owned subsidiary of Celebrity Builders India Private Limited, incorporated to assume charge of the parent's consolidated Bengaluru undertaking. The Bengaluru undertaking in its entirety was demerged to BCBIPL, which is the applicant in the given case, in 2020, which was approved by this esteemed forum in 2023. Your Lordship, the parent subsequently built a residential project and seeks to include the same within the first demerger, which the respondents contest. Over the course of the next 20 minutes, I shall endeavour to contend three issues. The acceptability of the application for modification, we contest that. Secondly, the applicability of stamp duty on the impugned transaction. Lastly, the application of goods and services tax. My learned co-counsel shall address the remainder issues pertaining to income tax and tax evasion. Your Lordship, prior to delving into the submissions, the counsel finds himself compelled as an officer of this tribunal and bound by the ethics of his profession to point out two among major instances of the petitioner blatantly misleading the court through the memorial submission and through the speech as well. Your Lordship, the first instance, I would request the bench to refer to citation number 29 of the memorial submitted by the petitioners, page number 21 of the memorial, where they refer to a Bharat Petroleum case, Your Lordship. Your Lordship, this case is wrongly cited. This case does not exist at all, and we have attached proof based on the citations provided by them. It is in the last page of our compendium, Your Lordship. You can find that we ran an SEC search and this case does not exist. The petitioner went a step further and researched on which case does this exactly pertain to. This is a Bombay High Court judgment which talks about application of GST on kerosene, which is clearly not relevant to the given situation.
No,
given
is it your case that that case itself is not there?
The case
Or
does-
is it your case that that ratio decidendi does not arise from that case?
Your Lordship, two contentions. Firstly, the case does not exist before the Supreme Court as has been contended. A case with a similar name.
It is from Bombay High Court.
Yes, Your Lordship. A case with a similar name is in Bombay High Court, and even that case remotely is not connected to the facts of the given matter.
You mean to say they have fabricated one judgment and they are citing it in their favor?
Your Lordship, the council states that this authority has been wrongly cited, and this raises serious apprehensions on the other authorities also. There's one more example, Your Lordship. Page number 11 of the Moot proposition. This is citation number 17. The case relied by the petitioners. This is a Gujarat High Court submission, Gujarat Urja case, which has been cited. We have taken a note 3 times in the entire speaking round. Your Lordship, it deals with the insolvency and bankruptcy court specifically, and there's a tangential interpretation which has been taken out of context, Your Lordship. So the council submits that based on these reasons, the authenticity of the authority submitted by the petitioners needs to be subjected to a scrutiny.
One question to you.
Yes, Your Lordship.
If we assume that non-existent case is cited before us, it's a fraud on the court. Who said fraud vitiates everything? Which judge of which country?
Your Lordship, the council pleads ignorant presence, but as an officer of the court, he promises the tribunal to approach the tribunal with a subsequent submission.
Okay. Anybody from the audience? Fraud vitiates everything. All right. You may say why judges should not answer. We will answer now. It was Lord Edward Coke in 17th century said, fraud vitiates everything. Then the apex court of our country accepted it in P. Chengalavaraya Naidu's case. Just look into your Google and come back. Just you have to look into, some students have to look into. Edward Coke, Lord Edward Coke, he was the Lord Chancellor of England. All right. And
Much obliged, Your Lordship. The council proceeds with its first submission on why the application that has been sought by the petitioners should not be accepted. 3 reasons. Your Lordship, primarily the application is not maintainable, it is time barred. Secondly, this application, this nature of modification is permissible only for apparent errors. Lastly, an unscrutinized modification will go against the very interests of justice. Your Lordship, the petitioners have relied on section 420 of the Companies Act. The Supreme Court of India in Marshall Sons and Co. India Limited, this is page 9 of the compendium which has been submitted by the petitioners, page 22, paragraph 22, and the Delhi High Court in Geometric Limited 2017, page 22 of the submission, they have affirmed that appointed date governs enforcement. Your Lordship, furthermore, the Ministry of Corporate Affairs, through a General Circular number 9 of 2019, which was a clarification to provision 232 subsection 6 of the Companies Act, which defines appointed date, stated that appointed date is when the scheme takes effect. Your Lordship, if the bench is with me, paragraph 5 of the Moot proposition states that the scheme was deemed operative, the appointment date was 1st of April 2020. The limitation period of 2 years given under this given section extends till April 2022. However, paragraph 10, Your Lordships, it states that the modification application was filed before this tribunal on June 30th, 2024, well beyond the prescribed time period and hence is time barred prima facie. Your Lordship, the date when this application was filed is 30th June 2024. The date of operation, the original appointed date is 1st of April 2022. We contend that based on the limitation period of 2 years, based on section 420 of the Companies Act, the application, if it had to be filed by April 2022. They filed the application on June 30th, 2024, which is 2 years, more than 2 years actually beyond
What happens to the Supreme Court orders extending the limitation periods during COVID?
Your Lordship, the Supreme Court order, if the counsel is not wrong, the honourable member is referring to the suo motu writ petition number 3 of 2020.
Correct. It
Your
extends
Lordship,
the limitation.
yes, Your Lordship. Your Lordship, this extended the duration of limitation. The limitation period was until March 2022, Your Lordship. Currently, Your Lordship, the date in which this application was filed before this bench, it's 30th of June 2024, Your Lordship. So even after COVID, they are still delayed in filing this petition and this is barred by time.
No, the 2-year period, the apex court could cite in 3 judgments. One of them you cited now.
Yes, Your Lordship.
While computing the period of limitation, the COVID period should be minused. If that is minused, what will be the period?
Your Lordship, may the counsel refer back to the bench on this in a minute after doing the calculations.
What is that big calculation? We are not asking you to
Please
do
tell
that.
us now what is your
Arbitrage
it is your
calculation.
application. You should
Your
know
date.
this.
You have to stand up and argue. We cannot stand up. Therefore, we are asking you to stand up. Even forgetting COVID, we have all forgotten now. So even if it is forgotten also, still within the period of limitation is your anyway. Okay.
Your Lordship, proceeding further.
What do you have to say for that? The council
Your Lordship,
says it is from the effective date of passing the order.
Your Lordship, the council contends that calculating limitation from the effective date is wrong because there's enough authority to ensure that appointment date is what is the date of calculation. There's enough.
Give me one authority.
Your Lordship, Supreme Court, the Apex Court of India and Marshall Sons and Co. Limited.
No, Marshall Sons Limited doesn't touch this ratio at all. Let's be clear on that. It only says that the appointed date goes back to that date.
That's all relation.
That's all. It's in relation to Income Tax Act, the operation. It doesn't touch on this aspect. So please.
Your Lordship, even if Supreme Court and Marshall Sons and Co. Limited is not considered, the Ministry of Corporate Affairs circular.
That circular is only indicative of a 1-year period.
After all, what is the value of the circular? We are bound by law, not circular of the government of the day.
Absolutely.
Your Lordship, that was the clarification.
Who wanted clarification?
Your Lordship, if the council may proceed with his subsequent submission.
You are not answering. What is the status of circular? Is it a delegated legislation?
Yes, Your Lordship.
Subordinate legislation?
Are we bound by it?
Your Lordship, the tribunal is not bound by it. It's a mere supplementary submission which has
You can bring some story from Alice in Wonderland. Even that does not bind us. you have to say something on the status of the circular. If circular is relatable to any provision of law, then it partakes the character of a subordinate legislation, delegated legislation, to use words of Jain and Jain, I.P. Massey, S.P. Sathe. If we use their terminology, it's a delegated legislation. You tell under which provision of law this clarification is issued. Who asked the clarification?
Shall I read it out to you?
Your Lordship.
Where the appointed date is chosen as a specific calendar date, it may precede the date of filing of the application for scheme of merger amalgamation in NCLT. However, if the appointed date is significantly antedated beyond a year from the date of filing, please note that
Your Lordship.
the justification for the same would have to be specifically brought out to the scheme, and it should not be against public interest.
That's all.
When they filed the scheme, when they filed it before us, the appointed date was indicated as a date after that, 1/4/2020, hardly few months.
So reckoning date, which is the reckoning date?
So there is no significant delay, is what
That's
we are trying to put
That's
before.
what they are saying.
Your Lordship, even acceding to this submission that the application is not time barred, the Council would proceed with the subsequent submission that such a modification as has been sought by the petitioners is applicable only for errors apparent on record.
No, where does it say? Please tell me which
Which
provision of law, section in
Your
Companies
Lordship,
Act
this
says.
is section 420 subsection 2 of the Companies Act which has been
Please come to 231, 232. 231 is very clear.
231, 1B.
Yes.
Please read that.
Kindly read that, please, for our benefit. Or shall I read it out to you?
No,
Lordship, the Council.
He has taken fee.
I know. I'm still in my old memory of appearing before Lordship.
Your Lordship, 232.
231, 1B. You should know under which provision they have approached us.
Your Lordship, they have approached the bench under 420 subsection 2.
That's for limitation.
That's only for limitation.
This read just that.
Your Lordship, 231, power of the tribunal to enforce compromise or arrangement.
Yes.
Where the tribunal makes an order under section 230 sanctioning a compromise or an arrangement in respect of a company, it shall have power to supervise the implementation of the compromise or arrangement, may at the time of making such an order or any time thereafter give such directions in regard to any matter or make such modifications in compromise or arrangement as it may
Yes.
consider necessary for the proper implementation of the compromise or
Yes.
arrangement.
Yes, it is there. Express power is there. We can consider.
It is their case that unless this property is included, the demerger scheme will not be
Not
complete.
work
It
at
will
all.
not work.
And it is a significant property for them.
You will have to show to us that it is so abhorrent to the scheme, we should not approve it.
Your Lordship, addressing this concern also, the Council argues that the applicant seeks to add a whole asset over here as a demerged property. Your Lordship, the Council argues that there was not an intention, there probably was an intention on their part to add the subsequently acquired asset as a part of the original asset, but that is not adequately materialized according to the requirements of this provision, because had there been a bona fide intention, as has been contended by them, the period in between, the 1 year 6 year period in between, 1 year 6 months period in between the date of effective order and when this application was filed should not have been 1 year 6 months, Your Lordship. The Council contends what were the applicants waiting for. Furthermore, Your Lordship, this has been contended by them as an error, as an omission. The Council seeks to rebut the same, citing Hari Vishnu Kamath versus Ahmad Ishaq, as has been pointed out by Your Justice, by Your Lordship. This is also there in our Moot, in our compendium, page number 27 and 28, where modifications requiring extensive discussion indicate the absence of an apparent error. Furthermore, Your Lordship, the NCLAT in Prithvi T Co. was Private Limited versus Regional Director reinforced that amendments must be apparent without requiring additional argumentation. Your Lordship, if they have to come before this bench and argue, make elaborate submissions to include this transaction, where it prima facie was not a part of the original application, Your Lordship, that shows that this is not a mere addition in pursuance of the scheme. This is a different transfer altogether which they are seeking to effectuate by the virtue of this application, which doesn't hold good.
Are there any decisions you have in your favor other than what you are citing?
Beg your pardon, Lordship?
Are there any rulings?
Are there any decisions which say we shouldn't do this? Let me put it that way.
Your Lordship, ruling 150, ruling number, rule 11 of the NCLT rules 2016.
No,
Case law.
decisions.
Case law. Rulings, I meant.
Rulings.
Case
Your
laws.
Lordship, this would bring the council to a subsequent submission where he says that an unscrutinized modification would violate the interest of justice. Your Lordship, the NCLT is indeed well within its powers to pass such a modification. However, the council humbly makes this contention that if this is done without scrutiny, it would set a very bad precedent before all the economic community. He'll begin with the citation of NCLAT in Vikas Dahiya versus Arrow Engineering Limited Private Limited. This is page 31 and 32 of the compendium, where it was held that reopening settled issues, it prolongs litigation and burdens stakeholders. Further, courts have considerably maintained that final orders should not be disturbed without compelling reasons. Your Lordship, the demerger order was settled on merits. Modifying it without a clear legal ground undermines the finality of the order.
There is one aspect.
Your Lordship.
You are harping upon finality of the order.
Your Lordship.
They are harping upon justice. So there is some conflict between finality and justice, which should prevail.
Your Lordship, their claim of justice has been contended by the petitioner to be malafide, and to further elaborate on this, he would like the bench to allow co-counsel to elaborate it in as an issue where he talks about tax evasion as a construction of how exactly this is a malafide petition. Your Lordship, proceeding further, if the council, in view of the paucity of time, may make his submissions on the GST aspect of issues. Your Lordship, the council contends that the transfer of under construction building, as in the given case, the building as a whole and not the units, the building as a whole is an under construction property. It attracts GST both under the CGST and the KGST Acts of 2017 under two prongs. Firstly, Your Lordship, it does qualify as a supply under section 7 and even otherwise under schedule 1 of the Act. Secondly, it does not qualify as a transfer of a going concern. Your Lordship, addressing the issue on basis of schedule 1 itself, entry number 2 of the Act states that considerationless supply between two persons when made in furtherance of business constitutes supply. Your Lordship, while the petitioners have contended that there is no furtherance of business, quite the contrary, paragraph number 4 of the Moot proposition states that how Celebrity Builders India Private Limited wholly owned its subsidiary Bengaluru Celebrity Builders India Private Limited with the whole motive of ensuring that all the sales and all the assets and liabilities in the Bengaluru market are affected to the subsidiary. The whole intention behind this transfer was so that the subsidiary could subsequently sell these assets, and there's an element of commerce involved which cannot be rebutted. Furthermore, Your Lordship, this does not qualify as a transfer of a going concern because firstly, this is a mere asset and not an enterprise. Serial to Notification 12 of 2017, which has been relied upon by the petitioners, it exempts only a transfer of a going concern in whole or as an independent part. The Authority for Advanced Resolution of this state, Karnataka, in Rajshri Foods Private Limited, requires an enterprise transfer to include immovable property, unexecuted orders, goodwill and insurance of business
1 minute,
community.
counsel. Are the decisions of the Authority of Advance Ruling binding on us?
Your Lordship, they are not binding, but with reference to
Then please tell me from the GST Act, are they binding on us or not?
Your Lordship, the council believes they are not binding on the tribunal.
Are they binding on them?
Your Lordship, these have been cited in a persuasive measure.
Are
Don't
they
want to
binding on
answer.
them?
Answer can be binary.
You can
Yes
say
or no. Then you can explain.
Are they binding on them?
Your Lordship,
The decision you are quoting, is it binding on them?
Your Lordship, the council maintains it's binding on them since they are seeking a GST
Please
exemption.
look at section 103 of the CGST Act.
Your Lordship, may the council look into this provision
Please,
subsequently.
What do you therefore mean by an authority? Is it a special tribunal? Are you aware of what is this concept of authority for advance ruling? Are
It
you aware
only
of
binds
it?
the
a
parties
party-
who are to
party
who have
specific
referred.
orders there.
It has nothing to do with the third party. Please keep
They
that
are,
in note.
they are not
And,
orders in rem.
When you talk of GST,
Person.
you also have to address us on the effect of section 87 of the CGST Act. Because their stance, though they have not taken it, would be this, that from the appointed date up to effective date, they would have already discharged the taxes in terms of section 87 of the CGST Act.
Your Lordship,
So how will there be a tax evasion or tax avoidance?
Your Lordship, taking due acquiescence of the court's inputs on authority of advanced ruling, the council cites Delhi High Court in Indorama Textile Limited, this is paragraph 41, page 22 of the compendium, which held that an undertaking must constitute a business activity and not just a standalone assets. Your Lordship, here before the review application was filed, the subsidiary had already taken over the affairs of the under construction units. It was carrying out all the business functions, and the only thing left was the transfer. Your Lordship, if we talk about this transfer in individuality, it's a mere transfer of a series of assets. Hence, Your Lordship, GST accrues on it. In arguendo, even if an undertaking is assumed, it does not qualify as an independent part. Your Lordship, the Council would again indulge in citing an authority on advanced resolutions authority merely as a persuasive order and would leave it to the wisdom of this tribunal to decide better. Your Lordship, transferring a branch of the same business vertical is not a going concern, rather an independent part. May the Council be given an extension of 2 minutes to summarize his arguments. Your Lordship, an independent part must be a distinct business vertical. The under construction building claimed by the applicants for inclusion is claimed to be included under the original demerger under the Bangalore undertaking. The resolutions passed by the CBIPL and the BCBIPL in June 2024 indicate that the building was always meant to be included in the demerger under Bangalore undertaking. Your Lordship, this adequately establishes this was never meant to be an independent part or an independent undertaking, but a part of a broader undertaking of Bangalore real estate units of the parent, and hence this does not qualify as an independent part and a transfer of a going concern. Hence, Your Lordship, the Council pleads that in the given situation, the notification sought after to be relied upon by the petitioners cannot be relied upon by them, and GST exemption doesn't apply. And the Council will just make a final submission with reference to stamp duty, where he states that in light of his aforementioned submission, where the applicant have moved this application under a false belief of a demerger, the transfer does not amount to one, and it is subjected to Article 21 of the Karnataka Stamp Act in Schedule 1, attracting a 5% stamp duty plus an additional 1% registration charge, leading to a charge of total 9 crores on the assets valued at 150 crores, as against a claim of a levy that has been claimed by them under the relevant provisions.
Therefore, it only supports their case. They cannot have any tax saving here. Anyhow, they have to pay 5%. Either it is, if it was their argument that they would want the benefit of 3%. But if you were to say that it is actually 5%, and if you were to accept it, then there is no tax avoidance, at least to the extent of stamp duty. Are they not paying a higher rate of stamp duty then?
Your Lordship, the Council contended that the stamp duty that they ought to pay is under 20 subsection 1, which is 5% on the conveyance and 1% on registration, amounting to a total of 6%, which amounts to rupees 9 crores. Your Lordship, whether or not it's a tax avoidance is something the co-counsel will address, and he has submissions to the same effect.
What is the stamp duty for conveyance of by way of sale?
Your Lordship, it's 5%.
Same. Either way,
Where is the avoidance?
Further, Your Lordship, there's a 1% registration, so total it comes to 6%. And Your Lordship, the avoidance aspect shall be taken by the co-counsel.
No, my brother judge is saying, even otherwise that will be the stamp duty. Exactly. Where is the avoidance?
Your Lordship, the 1% registration part that they're skipping, that would be absent, Your Lordship.
So you mean to say that there's no registration part in case of registering a demerger scheme? If you were to pass an order, you mean to say that only for the purpose of 1% they are here? If you have understood correctly, you are saying that in case of a sale deed, there is 6% stamp duty, 5% stamp duty and 1% registration charge. Whereas in case of a demerger, there is only 5% stamp duty and there is no registration. Is that what you are saying?
Even their registration is needed, no?
It's there. Both ways you
After
have
all,
to
registration fee is not stamp duty.
It's separate.
Where do you stand?
Your Lordship, even
You missed something on valuation.
Your Lordship, even not considering the stamp duty aspect of it, there are broader tax implications as contended under the GST and Income Tax Act. So the Council would like to rest his case and hand it over to his co-counsel.
Let us see what your friend will say.
Focus on GST and other losses to the GST and income tax, not just the stamp duty.
Understood, Your Lordship.
Yes.
3%. Discuss whether we are satisfied.
Certainly,
Straight away,
Your Lord.
barring
I
these
must
two, go on
admit that I
arguing.
was harsh with you, but you have come out well. I was harsh with you, but you have come out well.
Your Lordships, I am the counsel on behalf of the respondents. I shall be arguing for 20 minutes. I shall be making two primary submissions. Firstly, that the income tax liability arises out of the current transaction. And secondly, there was an attempt to evade legitimate dues by the assessee by the way of tax evasion. Proceeding with the first issue, the issues arising on the...
One second.
Yes, Your Lordships.
There should be profit. Should be less sale. Correct. Now if you sell it, you are only, where is that, what is the sale price today for that material? They are arguing.
May I proceed?
Yes.
Your Lordships, the issues arising on the income tax liability front are if the transfer of the completed and the under constructed units from the parent to the subsidiary company attract any income tax liability, specifically if the subsidiary is entitled to complete some of the units, is it a transfer under the Income Tax Act read with the Transfer of Property Act, and would capital gains apply on the transferred units? Your Lordships, my submissions today are based broadly on any income tax liability arising out of the entire transaction, inclusive of the aforementioned specifics. I shall be establishing the income tax liability via three main submissions. Firstly, the transferred assets constitute capital assets. Secondly, the transaction is regarded as a taxable transfer under Section 2, subsection 47 of the Income Tax Act. And thirdly, the transfer is not exempt under the Section 47 of the Income Tax Act from being regarded as a taxable transfer. Proceeding with the first submission, Your Lordships, as per Section 2, subsection 14 of the IT Act, property of any kind, whether or not related to the assessee's business, is a capital asset. And property here means any possible interest that one can clearly hold. Your Lordships, the nature of an asset to be a capital asset is decided with regard to the prevailing facts and circumstances during the transfer and not when they were acquired. It has been held that even if it's a business as a going concern or if it's a conveyance of an immovable property, all of this can be classified as capital assets. Your Lordships, placing my reliance in the Fort Properties case, which is given on page 76 of the compendium and page 77, para 14 and 17 respectively of 76 and 77 pages, it has been held that one can be a real estate developer with regard to some properties and may still hold other properties as investments. Every transaction of a company set up with the intent of business in real estate, Your Lordships, does not mean that it is for the purpose of a business directly. Investments have been held to be assets held by an enterprise for capital appreciation. In the present case, Your Lordships, if you could refer to the second line of para 7 of the Moot proposition on page 3, even though the parent company received several offers from the buyers and there were some ready to sell units already completed by December 2022, there is still no transfer made in the name of any of the buyers, signifying that they are clearly holding onto the property for capital appreciation. Also, Your Lordships, I will proceed to say that even if it is contended that this is a transfer of a business in its entirety, the transferred assets still can be categorized as capital assets. This can be construed from the fact that even though the applicants were in the real estate business, the assets were excluded from the demerger and were independently acquired. Your Lordships, all these facts, the facts coupled with the immediate not facilitating of the sale even of the ready-to-sell units, despite offers and their own advertisements, portrays that these are actually capital assets. Your Lordships, with your permission, I will proceed to establishing that this is a taxable transfer under the Income Tax Act.
Please tell us where it is said it's a capital asset.
Your Lordship, Section 2, subsection 14 of the Income Tax
Does it not exclude stock in trade?
Yes, Your Lordships.
Why isn't not stock in trade for them?
Your Lordships, firstly, they themselves did not even contend that this is a stock in trade.
No, let them not contend. But
We
we
are
are
asking-
here to do justice.
Yes, Your Lordship.
Can we refrain from doing justice because they have not argued well?
No, certainly not, Your Lordship.
For marks purpose, well and good. But we have to do justice.
Yes, Your Lordship.
That's what the oath we have taken.
Yes, Your
To
Lordship.
uphold the law and the constitution. Is it not?
Yes, Your
Therefore, don't depend upon their argument.
Certainly, Your Lordships. I placed my reliance on the Fort Property case, Your Lordships, and also on multiple facts, even in the present case, which showed that even if they are real estate developers, They are still holding on to these properties as capital assets, your lordships.
No, let me ask you this question. Intervening was COVID. Obviously, they are not going to get a good sale price. So they held on to it to sell it at a, when it becomes better at a better price.
Hoping that
what is wrong?
everything will be
That
all
by
right.
itself will not make it an investment. It will still remain stock in trade. Is the proposition we are placing before you? Kindly answer it.
Yes, your lordship, if you could refer to para 7 of the Moot proposition on page 3, the second line, your lordships, the offers they were receiving for the sale was in 2022. Your lordship, COVID era was...
At what price it should be sold, it is their commercial wisdom.
commercial
Because there is a delay in selling it, can a stock and trade get converted into an investment?
No, your lordship, I also pointed out that an investment has been held by the accounting standards 13 to be something that is being held upon
So
by the...
if that is the case, how long has these asset been in their books of accounts? Have they been carrying it perennially for several years?
Yes, your lordship,
No, the construction itself, when did they purchase it in the year?
2020.
And when did they actually ultimately transfer, intend to transfer?
Your lordship, they were in 2023.
They had all the assets. The intention of the original main application itself was all the assets that are purchased by the parent is meant to the subsidiary. So moment they purchase, the intention
That
is to
also
pass on,
becomes
goes. So therefore they had no intention to hold on to it. The parent company did not have any intention to hold on to it. Therefore this theory that they were holding on it, therefore treat a stock and trade as an investment would not stand.
I humbly disagree with this contention, your lordships, because I mentioned that they are holding on to it specifically for capital appreciation, as your lordships themselves pointed out that, okay, what can be the price at which it can be sold at? They are holding on to it for...
That is not capital appreciation, because now turning it on us. It is not for capital appreciation. It is because I have incurred some cost, I would have some price at which, markup at which I would like to sell. So if there is an offer less than that, I may not like to sell. That is not waiting for capital appreciation, isn't it?
Yes, your lordships, however, I will also highlight one fact. Your lordships, given on the third line of para 9 on page 4 of the Moot proposition, your lordships, if we look at what was the intention and the actions of the subsidiary when they claim that the subsidiary has received these properties, your lordship, it is given there that even they did not act on the plan of selling this, your lordships, and instead focused on other projects that they actually aim to sell. So let's consider that that it was a valid transfer only for the purposes of this answer, your lordships. Even the subsidiary, when they are considering that they hold the assets, they were not willing to sell it, your lordships. They were also holding on to it. The parent was also holding on to it. But your lordship,
How this would support your argument, assuming that it is not actually stock and trade? How would that support your argument?
your lordship, so if this is not stock in trade, it is clearly liable to be taxed under the head of capital gains, your lordships.
But it is also falling under, they are relying on 47 clause 6b,
Yes, your
which
lordship.
says that in case of a demerger, assets transferred by way of a demerger, qua a demerger, will not be subject to tax. It's clear.
Yes, your lordship. However, they are the entire arguments that were made by the learned applicants was on the assumption that this demerger will be approved, your lordships. That is why, your lordships, my honorable co-counsel had proceeded to first and foremost argue that this demerger should not be allowed, your lordships.
That is in the event we accept your arguments. If you were to accept that it is part of the original scheme, then they would succeed, isn't it? So what are your points, legal arguments to say? While we understand that you are very anxious that it should not be approved, but what is your argument to stop it? Why would you say it is not, it would rather be liable to capital gains tax?
Certainly, your lordship. So if we look at the definition of section 2 subsection 47, where they define what a taxable transfer is, it has held that even if there is a transaction that allows the possession of an immovable property where the transferee might be willing to fulfill a part of the contract for a consideration, then there is no formal registration that is required. Your lordship, our primary argument is that there was no proper material disclosure of including this property into the demerger by the applicants. They are only doing this, your lordship. I will now come to the intent part of this. Your lordships, when did they decide to come to the honorable NCLT? They only decided when their buyers, their prospective buyers, receive legal opinions that the subsidiary does not hold the valid title to sell these units to you. When they realize that they are not able to sell this, for only commercial reasons they came to the NCLT, your lordships. There is no bona fide intent. Going by the Moot proposition, yes, your lordship.
Once we have approved the scheme, it dates back to 1/4/2020. all transactions after that are done for the benefit of the subsidiary. So what really is the problem? There is absolutely no problem.
Your Lordship, we are going into the intent of the entire transaction.
I'm saying, as per our original scheme, 1/4/2020 was the appointed date. After that date, whatever transactions are done by the holding company are done for the benefit of the subsidiary. That is how Marshall and Sons and all other decisions say so. If that be the proposition, what is wrong?
Your Lordship, what is wrong in this case?
And anyway,
Yes,
keeping in mind section 170A of the Income Tax Act, assessments will be done in the hands of the subsidiary. So what is the problem?
Your
What is the
Lordship,
problem?
Your Lordship, the case that I subsequently seek to argue is that what they are trying to do in this case, Your Lordships, is tax evasion. It is an attempted tax evasion, Your Lordship. Our case is based heavily on intent, Your Lordship. Your Lordships, that is why I pointed your attention towards this fact that they knew of the oversight before they tried to sell these assets to the prospective buyers. If you know of your own
One thing we make clear.
Yes, Your Lordship.
None of the judges has bought any of the flats in question.
Your Lordship, I think that is a very wise decision because God knows who actually holds the title to these properties.
The holding company owns it, goes to the subsidiary.
Your Lordship, the holding company owns the title and the subsidiary is trying to sell the properties.
But they have passed board resolutions.
They have
to
passed
that effect.
resolutions in there, the creditors have approved it. What is wrong in us approving it also?
Your Lordships, I am coming back to my argument again, Your Lordships, where I am delving into the intent of this transaction. They knew of this oversight as per the Moot proposition before they tried selling it to buyers. If you are aware of your owner side before selling it to your buyers, why are you approaching the court only when your buyers are objecting it? If the
Had they sold it to buyers, where would have been the property to be merged at all?
Your Lordships, but if they would have sold it to the buyers without this property included into the demerger scheme, the subsidiary would not even hold the correct title to sell off the units. Your Lordships, that is the main contention. If Your Lordships agree to this, the council can proceed towards establishing how they are attempting to evade taxes, Your Lordships.
Yes.
Your Lordships, first and foremost, the assessee engaged in a dubious and a colorable transaction, Your Lordships. Honorable members, it was held in the V. Vikram Reddy Bangalore case that if the transactions are dubious, sham and colorable, then such arrangements cannot be veiled under the guise of tax planning as they tried to construe it as. Your Lordships, transaction should be real or genuine and not a sham or a make-believe. In the present case, Your Lordships, the parent company, despite the pending demerger, purchased new assets and attempted to transfer them to the subsidiary, that too tax-free, all without any information to the NCLT as given in para 10 of the Moot proposition. The SSE also tries to basically dodge its legitimate dues by the way of this. Also, Your Lordships, whatever contentions they are raising are after we have taken the cognizance of this issue, Your Lordships. When they pointed this out to the NCLT, they were already in the process of selling it. Your Lordships, even if we were to consider that, okay, the NCLT will subsequently approve of the subsidiary owning these units, they attempted to sell it, even when the subsidiary did not hold it, Your Lordships. Your Lordships, this is clear. It is very clear that they attempted to sell it without holding the right title to it and only decided that it is wise to approach the NCLT when this was coming into the legal opinion of the buyers, Your Lordships. That is why this is an attempted tax evasion, Your Lordships.
How that would be an argument to say that they are also trying to evade tax?
So,
At best, they are trying to sell a property on which they don't have a title, according to you. How that would be relevant to say that they are also involved in tax evasion?
Your Lordships, that is not directly relevant to my tax evasion argument. Why I am saying that is, I am firstly highlighting the overall intent behind the transactions that this company enters into, Your Lordships. Your Lordships, how I am linking it to tax evasion is that they had not validly transferred it to the subsidiary. So they skipped the tax liability that would have arisen when if that transfer would have been taken into account, because we contend it falls out of the scope of the demerger. So they evade the tax liability of giving these units to the subsidiary And then on the premise of that, now the subsidiary is further acting to convey these units to the buyers without even having a right title. Your Lordship, basically this case that I am trying to put forward shows the overall malified intent on part of the applicant in this case, Your Lordships. That is why it was very, very important for me to show how these are capital assets, how it was important for my co-counsel to show that this is outside the scope of a demerger, and how validly capital gains tax should be liable on this transaction, Your Lordships. Your Lordships, the counsel was also prepared to argue in arguendo that if the bench considered these to be stock in trade, how they should have been taxed under the head of profit and gains from business or profession, Your Lordships. Anyways, they're not going to escape tax liability even if they were to argue stock in trade, but it did not delve into that question itself.
Could you please focus on the point how they have evaded stamp duty or capital gains tax or any other GST? Please focus on that instead of just complaining that it's a colorable device.
Certainly, Your Lordship. So, if the counsel is correct, the issues regarding to stamp duty and GST have been touched upon by counsel number 1. However, I will certainly be in a position to explain how they would have avoided capital gains tax, Your Lordships. Your Lordships, if we look at section 47(6)(b),
One second. What is the capital gains tax concept?
Your Lordships, the basic concept is that if it's a capital asset as defined under section 2 subsection 14,
Correct.
it is being transferred from one person to another person.
For a higher rate.
Yes, Your Lordship.
What is that higher rate now?
Apologies, Your Lordship. The council.
One second.
Yes, yes.
The idea of capital gains tax would arise where the sale price is higher than price of acquisition. Is it not?
Yes, Your Lordship.
Where is the price of acquisition? Everybody has speculative argument. What is the price of sale now?
Your Lordships, firstly, I humbly submit that this is not a speculative argument, Your Lordship. And secondly, the Moot proposition has not exactly given us figures apart from the intended value that would be 3 CR. However, I will highlight, Your Lordships, how the value is increasing. Your Lordship, when we look at what the parent company acquired firstly was an empty piece of land on which they decided to construct a commercial complex. Your Lordships, when they took an empty land, constructed commercial complexes on it, the entire value of that land and the building increases. And then, Your Lordship, they are transferring it to the subsidiary company. Therefore, at a capital gain, the capital gain should be liable at that point of the transaction itself. When they take a vacant land, make it commercially exploitable, and then they are giving it to the subsidiary, Your Lordships. That is my contention, Your Lordships.
What are the quantum figures? You have any figures about what is the implication of GST loss or loss of income tax as per your argument?
Lordship, I would be more than obliged to submit the figures. However, Your Lordships, the council is bound by what has been the information that has been provided to us, and I don't think it will be valid for me to go outside of what information has been provided to me.
In support of your own argument, what are the actual losses that would be to the revenue?
Your Lordship,
from the total stamp duty, stamp tax, and also.
You should have asked your client to furnish all information. Otherwise, you should have told him. Otherwise, you are likely to lose the case.
Is it a wholly owned subsidiary?
Yes, Your Lordship, it has been given in clarification 1 of the Moot proposition.
Okay.
It is a wholly owned subsidiary.
It is so. Will not 47(4) apply even if the merger is not approved?
Yeah, Your Lordship, if we look at the proviso to section 47 subsection 4 and 5, Your Lordship, it is given there that if it is a capital asset that becomes a stock in trade in the hands of the transferee after February 1988, Your Lordships. Your Lordships, may I continue? Yes, Your Lordships, so the proviso to section 47 subsection 4 and 5 reads that if there is a capital asset that becomes a stock in trade in the hands of the transferee after February 1988, then it will not be given this exemption under section 47 subsection 4. Your Lordships, precisely in this case, despite...
That is for conversion of capital asset to stock in trade.
Yes, Your Lordship.
But otherwise, a transfer from a holding company to a subsidiary, wholly owned subsidiary company, does it have to go through the demerger route at all of having our consent? it can still be exempt under 47(1)(4). If it is so, there is no tax evasion.
Your
That is the
Lord-
proposition we are putting here.
Certainly, Your Lordships, the council answers that proposition by simply relying on the proviso to section 47, subsection 4 and 5, which reads that if there is such a conversion, Your Lordships, now I will establish that while this is primarily a capital asset, in the hands of the subsidiary company, it was clearly a stock in trade. Your Lordships, because let's look at the actual attempted sale of the units, Your Lordship. Despite having offers, despite releasing advertisements, it is not the parent who attempted to sell these off, Your Lordships. It is the subsidiary company that attempted to sell these off. Therefore, it is clear that the parent held it as a capital asset, but in the hands of the transferee subsidiary, Your Lordship, it is a stock in trade, and the exemption under 47 subsection 4 will not apply, Your Lordships. And the exemption under section 47 6b will also not apply, Your Lordships, on the basis of the arguments given by my co-counsel that this is not a valid demerger, Your Lordships.
One last question to you.
Yes, Your Lordships.
How to differentiate tax avoidance or evasion and tax planning?
Certainly, Your Lordships. Your Lordships, I will place my reliance on the case of V. Vikram Reddy, Bangalore, given on page 93 of the compendium. Your Lordships, can I take extra 2 minutes?
More minutes.
Much obliged, Your Lordships. Your Lordships, page 93 of the compendium that I submitted. Your Lordships, it reads that if the transactions are not dubious, sham or colorable, only then can they be construed as valid tax planning, Your Lordships. It has been clearly given that under the guise of tax planning, transactions that are actually dubious cannot be wheeled. Your Lordships, I'll also rely on the case of State of Karnataka versus MS Videocon International Limited, para 35 of this case, Your Lordships. It was given that such transactions should be real or genuine and not a sham or a make-believe. If the transaction is real or genuine and not a sham, then it can be considered tax planning, Your Lordships. But when there is even an element of ingenuity, Your Lordships, then that is not tax planning, Your Lordships. That is simply the wheel of tax planning that the applicants in this case are trying to cover their dubious transaction under. Because, Your Lordships, again coming to the core fact, they only decided to come to the NCLT when they were not able to sell these and when their buyers got a legal opinion. They did not do this despite being aware of the oversight, Your Lordship, as given in the Moot proposition. Your Lordship, that brings me to the end of my submissions.
But one question
Yes,
I
Your
have.
Lordship. Yes, Your Lordship.
You're relying on this decision V. Vikram Reddy,
Yes, Your Lordship.
which relies quite heavily on McDowell's case. With the ghost of McDowell's has been exorcised by Azadi Bachao Andolan case, which you have not referred to. Can they say that you have not put the judgments correctly before us, and therefore your your argument should not be accepted?
Certainly not, Your Lordships, because my submission today, while relying on the V. Vikram Reddy Bangalore case, is very simple and very straightforward. I am drawing a clear line. I am not doing any interpretation, Your Lordships. If I may take another minute, Your Lordships. Much obliged. Your Lordships, this case says in a simple line that if the transaction in any way is dubious, sham or colorable, then it cannot be wheeled under the guise of tax planning, Your Lordships. So I am simply relying on this, and this is not a ratio that would be countered by any of the cases, even the McDowell's case, Your Lordship, because this is the general position of law. By tax planning, you can't do something that is dubious or sham and just mislead the court, Your
You're
Lordship.
saying that they don't have any other incentive other than the tax savings. Is that what you're trying to say? The whole objective of before being us is only because of the tax incentive. Is that what you're trying to say?
Your Lordship,
In the sense, you would to say that if there had been no tax incentive at all, then they would not be us by way of modification application. So you're trying to project that only for the purpose of tax savings, they are before us. Is that what you're trying to say?
Your Lordship, not precisely, but this is one of the very important elements of it, Your Lordship, because what I am trying to say is that the overall nature in which the applicant's company is functioning is very questionable, Your Lordships. At one point of time, they had this, they were getting a validly approved demerger. they had many other alternatives that they could go for, and they, apart from a modification, for example, the parent itself could have sold these assets, completed and sold these assets, and rest of the assets were already transferred to the subsidiary company or lordships, so their demerger would stand valid. However, it is very important to uplift the wheel here, your lordships, behind the entire transaction, that when they had such a viable option, what is it that they are trying to do by seeking an amendment to the prior order given by the NCLT, your lordships? Your lordships, may I...
Can you cite one very famous judgment and doctrine of lifting the veil?
Your lordships, can I take a moment to...
Not to ask anybody, you only. Yeah, you take one moment.
I'll take a
One moment means 5 seconds.
Sir, your lordships, if I'm not wrong, is it the Cox and King's judgment? Which
Cox
talks
and King was more on arbitration, doctrine of group of companies,
Yes,
etc.
Yes,
Not on this. It is, but it's one of the factors. The famous judgment is LIC of India versus Escorts, 86 Supreme Court. Justice Vojinapareddy's judgment.
Calcutta chromotype.
Correct.
You see that.
Certainly, your lordships, I'll take that into account, your lordships. Your lordships, if the bench permits, may I read my...
You have understood your case also.
May I read my... Yes, your lordship.
One last question for
Yes,
you.
yes, your lordship.
The holding company and the subsidiary company, two separate legal entities. As far as shareholders are concerned, they are common. They are the same shareholders. If you want to tax the capital gain, or if you want to collect stamp duty, it is the market value realized on the date of transfer, right?
Yes, your lordship.
So transfer has not yet happened because the buyers, they have got some legal issues regarding the title. Only on selling to them, whether the holding company or the subsidiary company will be realizing the consideration. Only at that point of time they can pay the taxes. Right now they don't have money to pay taxes. Even if you say it is a transfer, it has a cascading effect. It's only postponing the payment of taxes. It's not a colorable device according to us. Could you please justify?
Certainly, your lordships, the council seeks to clarify that we are not seeking any tax liability as of now on the transfer of the completed units to the buyers, your lordship. We are seeking to apply these liabilities on the very transfer from the parent to the subsidiary. As your lordship himself mentioned, these are two separate legal entities. Just because the shares are held, some of the shares are held by the members of the parent company for the subsidiary company, we cannot avoid the doctrine of separate legal entities. Therefore, your lordships, we are seeking the tax liability on this transaction from the parent to the subsidiary.
Purpose of taxation, is it the market value? Is it the fair market value? Is it the guidance value? What are you adopting? Or is the book value? What are you adopting?
Your lordship, fair market value.
Is there any provision which enables you to invoke that? Now that incompleted work in progress apartments, how would you value them from the parent to the subsidiary?
Your lordship, if the council is correct, in all honesty, I'm not exactly sure of this, your lordship, but if we could refer to...
Too many caveats. You have too many caveats before answering. Which is the provision? Is there a provision which enables you to value it?
Your lordship, section 50C of the Income Tax Act, which has a deeming fiction where we go by...
You need to have a tax base
Yes,
to apply the tax rate.
Yes.
50C is the provision
Yes,
for all
Your
capital assets.
Yes, your lordship. Your lordship, with the permission of the bench, shall the council recite the prayer? Much obliged, your lordship. Therefore, in the light of the issues raised, arguments advanced and authorities cited, it is humbly prayed that the honorable court may be pleased to declare that the modification application ought to be rejected. Secondly, the petitioner is liable to pay an additional stamp duty on the impugned transaction. Thirdly, the applicant is liable to pay GST on the impugned transaction under the Central Goods and Services Tax Act and the Karnataka Goods and Services Tax Act of 2017. The applicant is liable to pay income tax, particularly capital gains tax on the impugned transaction under the Income Tax Act of 1961. The impugned transaction may be construed as an attempt to evade tax and whatever cost that your lordships may deem fit in this case, your lordships.
You could have simply asked to dismiss the application.
We can do only that. Beyond that, what can
You cannot do your assessment work.
Can they be worse off by coming to court?
Lordships, if they lose...
There is doctrine against worsening off. Do you know that?
Your
A
Lordship,
person cannot be given, suppose if he comes to your clinic saying that a small injury has happened, kindly treat it. Can you make it bigger injury? You can say at the most, I don't treat it. Is it not?
Your Lordship, honestly, council is not aware of the doctrine. However, Your Lordships, if we look at this current case and if additional facts, additional circumstances are coming to the light of the case.
All right, all right. We have heard you. Let us see.
Obliged, Your Lordship.
For the purpose of rebuttals, I shall confine myself only to the arguments that were advanced by respondents, and I will be contending only against that, Your Lordship.
Yeah.
Firstly, Your Lordship, they brought up the topic or the contention of time limit, Your Lordship. They said it's 2 years, Your Lordship, and they also contended that it starts from the appointed date, Your Lordship. However, only when the effective date gives effect to the appointed date and it says that the transfer of assets was carried out according to the appointed date, only from that point on can we consider that time limit can be 2 years from the point of effective.
Reckoning date.
Indeed, Your Lordship.
Next point.
Indeed, Your Lordship.
Next point.
Indeed, Your Lordship. Next, also coming to the intention part, Your Lordship, para 10 of the fact sheet is very clear, Your Lordship. It was intended to be transferred to the subsidiary company, Your Lordship. So there is no malified intention as such that was brought against by the respondents, Your Lordship. And further, moving on to the next point, Your Lordship, there came a question of ownership, Your Lordship. One, this is a wholly owned subsidiary company, meaning 100% of the shares is held by the parent company. And for the purpose of this argumentation, I shall also go on to say that the subsidiary company, and as they contended, the subsidiary company, why did the subsidiary company go on and try to sell the property, Your Lordship? For this purpose, we can consider that since the subsidiary company is a wholly owned company by the parent company, it was merely trying to act as an agent of the parent company itself, Your Lordship. So in that case, there is no question of two separate legal entities. Although these are two separate legal entities, it is carrying out only the agency of the parent company, and it's acting in its own interest, Your Lordship. And since they're 100% shareholders of the company, all the profits that are accruing go to the respondents themselves, Your Lordship. So in that question, where is there a capital gains tax or a question of us evading capital gains? If there is any capital gains, they also stand to make that capital gains is our submission, Your Lordship. And with that, we rest our case. You know.
All right. Thank you. Thank you. So we will have a cup of tea and come back. We are tired.
The council worked upon the request of the bench and upon the submission made by the respondents in the current rebuttal. He has worked out on the dates. Your Lordship, considering the suo motu petition of the Supreme Court, the writ petition, which condoned of delays until March 2022. Your Lordship, that was when the, yeah.
This March thereafter, it actually ends on June 30th, 2022.
Correct.
Thereafter the limitation starts. So they are on actual the last date of the limitation, strictly speaking. It was from 15/3/2020 to 36/2022. That has to be excluded while computing the limitation.
Your Lordship, even if it's excluded, there's an exclusion from April 2020 when they submitted the first original thing, and until June 2022, this amounts to approximately
2
around
years.
2 years. 2 years is the limitation period. Our contention under 420, the section under which they applied, under appointed date, the limitation would have ended on April 2022.
Now that depends upon the reckoning date. From which date to be reckoned? Limitation starts to begin. From which date?
Your Lordship, under the provision they have applied, Your Lordship, it begins from the appointed date.
They cannot contemplate a modification petition unless the main petition is ordered.
Correct.
They need to have an order to see what is the error in that or something which has been left out. So it is from that date you will have to reckon the limitation period.
Only 23 the order comes.
Your Lordship, there was a scope of this property having been left out from the effective order had this property existed at the time of the original order. They never submitted this as a part of the original application. Since this was not a part of the original application,
That we have argued now.
Your-
You have argued that. You have argued.
the effective order could not have also had this.
Yes.
Your Lordship, this would open a floodgate of cases. People would subsequently start acquiring properties and start putting it under this header to unfairly. Your Lordship,
We have to ration our time. There are many litigants.
Your Lordship, the council rests his case.
Thank you. Yeah, yes, yes.
Ladies and gentlemen, please rise as our esteemed dignitaries arrive. seeking the blessings of His Holiness Swamiji and offering my humbleness pranam to His holy feet. Good evening to one and all present here, and welcome to the valedictory program of the 22nd Surana and Surana National Corporate Law Moot Competition 2025, jointly organized by JSS Law College Autonomous, Mysuru, and Surana International Attorneys, Chennai. As we gather here to conclude this competition, let's take a moment to reflect on the exceptional display of knowledge, skills, and advocacy that have characterized the 2 days intense competition. Before we proceed, let's take a moment to seek divine blessings as I invite Ms. Amrita Lakshmi to invoke God's blessings.
जय गणेश पाहि मां जय गणेश रक्ष मां जय गणेश पाहि मां जय गणेश रक्ष मां मुदाकरादमोदकं सदा विमुक्तिसाधकं कलाधरावतंसकं विलासिलोकरक्षकम् अनायकैकनायकं विनाशिते भतैत्यकं नताशुभाशुनाशकं नमामि तं विनायकम् जय गणेश पाहि मां जय गणेश रक्ष मां जय गणेश पाहि मां जय गणेश रक्ष मां नटेतरातिभीकरं नवोदितार्कभास्वरं नमत्सुरारिनिर्जनं नटादिकापदुत्तरं सुरेश्वरं निधीश्वरं गजेश्वरं गणेश्वरं महेश्वरं समाश्रये परात्परं निरन्तरम् जय गणेश पाहि मां जय गणेश रक्ष मां जय गणेश पाहि मां जय गणेश रक्ष मां
Thank you, Ms. Amrita Lakshmi. I now request Professor M.P. Nagendramurthy, Professor, JSS Law College, to welcome the gathering.
So, ellarigu namaskara. Good evening, one and all. On this day, it is my honor to welcome the gathering. First and foremost, I deem it as my privilege to introduce and welcome Honorable Mr. Justice Krishna S. Dikshit, Judge, High Court of Karnataka. Honorable Justice enrolled as an advocate in July 1989. Since then, he was practicing in the Honorable High Court of Karnataka and High Court of Madras, specializing in law of writs, election laws, and service laws. He was appointed as the Senior Standing Counsel for the Election Commission of India and also as an additional government standing counsel since 1999. He has also served as a standing counsel for the University Grant Commission, the Competition Commission of India, the TROI, Karnataka Veterinary Sciences University, Baba Atomic Research Center, etc. He was appointed as amicus curiae in a few matters before the Honorable High Court of Karnataka. He was panel counsel for a few nationalized banks, and he was also a para-academician and part-time lecturer in Law College, Bangalore for a few years. He was contributing articles to few Kannada and English newspaper and magazines. He also participated in several television debates on matters of contemporary relevance. Having been appointed as the Assistant Solicitor General of India in the year 2014, he was appearing for the central government in numerous important matters till his elevation as a judge of the Karnataka High Court on 14th February 2008. Your Lordship, we feel esteemed to have your presence here with today. On behalf of everyone present here, I extend a warm welcome to you, sir. I feel delighted to introduce and welcome Sri V. Raghuraman, a designated senior advocate to the gathering. V. Raghuraman is a chartered accountant, cost accountant and company secretary, having passed all the 3 professional courses in distinction. He stood first rank in BCom in Bangalore University and secured 38th rank in CA Inter and 24th rank in CA Final. He secured second rank in ICWA Inter and 25th rank in ICWA Final. He has rich experience of 35 years in practice as a chartered accountant and as an advocate. He practices before Supreme Court, High Court and tribunals and is specialized in areas of taxation and foreign exchange matters. He has addressed more than 500 seminars and symposiums. He has authored several books which include landmark international VAT judgments published by International Publishing House Walters Floor, GST, and Indirect Taxes Demystified, published by Commercial Publisher. It is our honor to have you here today, so I extend a warm welcome to you, sir. I would like to extend a warm welcome to Sri Paramesh Gowda, G, Joint Commissioner GST. A hearty welcome to you, sir. A special welcome to Sri Preetham Surana, Partner, Dispute Resolution, Head, Academic Initiative, Surana and Surana International Attorney, Chennai. I would like to extend a warm welcome to our Professor Sri K.S. Suresh, Chief Executive, JSS Law College, Mysuru. A hearty welcome to you, sir. I also extend a warm welcome to Dr. N. Vanishri, Principal, JSS Law College. A special welcome to Karthik Ranganathan, Alumni and Standing Counsel, Income Tax, High Court of Madras, the man behind drafting the Moot proposition since 14 years. I welcome you once again. I also extend a warm welcome to Johnson Christie, Manager, Special Project, Surana and Surana Attorney, Chennai. Who is here with us from day one. A warm welcome to you, sir. A special note of welcome to the esteemed judges, advocates, judicial officers and special invitees who have taken time out of their busy schedule to be with us. Your presence is a testament to the importance of this event and we are grateful for your support and encouragement. A warm welcome to you all, sir. I am delighted to welcome student participants from different parts of the country. Your enthusiasm and eagerness to learn is inspiring and we are happy to have you here. A hearty welcome to you all. I would also extend a warm welcome to our staff members, both teaching and non-teaching, student coordinators and students of our college. Last but not the least, I extend my welcome to the members of the press and media. Leaving none and including all, a warm welcome to everyone present here. Thank you one and all.
Thank you, sir. On behalf of everyone present here, I welcome you too. It's my honor to invite Honorable Mr. Justice Krishna Dikshit, Judge, High Court of Karnataka, to deliver valedictory address.
Dignitaries on and off the dais, young lawyers, I felt so happy that the performance of the mooters was far better than the performance of seasoned lawyers. The author of the Moot problem is also sitting here. He deserves a special thanks, special congratulations, special appreciation. The way it has been structured, so in a very balanced way he has done that. The case is arguable from both the sides. And when a case is arguable equally from both the sides, you know the difficulty of judges. The difficulty of judges you should appreciate. The way the questions have been answered by the lawyers, budding lawyers, it made me so happy. I wish a section of tax bar should do it. I'm sitting on the tax roster. Last year also I sat on the tax roster. The way the questions were taken by the mooters and the way they very pleasantly answered made us all very happy. There was a volley of questions. There are at least two judgments of the House of Lords where they set aside conviction on the ground that judges had asked too many questions. When judges ask too many questions, sometimes the structure of argument goes awry. You will not be in a position to structure your argument at all. It is like in Avadhana, you will have some Adhika Prasangis to distract the attention. They will put all irrelevant questions. I do not know whether you know Avadhana, Ashtavadhana, Shatavadhana, Sahasradhana. If you are Professor or Ganesh, Shatavadhani, if you attend them, you will know. When too many questions were asked in Chamar Bagwala case, you have seen that RMDC versus State of Bombay, RMDC versus State of Maharashtra. Two judgments, very important judgments. What is gambling and what is gaming? What is lottery and what is game of skill? These aspects were discussed in these two matters. And Palkiwala was arguing. It was a larger bench. Judges started asking too many questions. Palkiwala was disheartened. In the evening party, he mentioned it to Daptari, the then Attorney General, Second Attorney General of India. Daptari Saab, the judges troubled me like anything. They don't permit me to argue at all. Whether I am arguing or they are arguing, it's very difficult to know. The judges should hear the argument. The lawyers should argue. Judges should hear. That is the tradition we have been brought up in. But that is not happening in the Supreme Court. Then Daptari said, wait, when again case is posted? He said, next week it is posted. All right, I'll do that something. Next day he went to court and told the Chief Justice, my niece had come to High Court, to Supreme Court, day before yesterday. And she was very angry. Oh, Mr. Daptari, why she was angry? She is a school-going child. She studies in high school. She was upset with the short man who was arguing the case. He was not allowing the judges to argue. Every time he would state something, but he was not permitting the judges to argue at all. Then Chief Justice learned, oh, perhaps judges were arguing more than lawyers were. We should not do that. Then he hinted to brother judges, we'll allow Palkiwala to argue the matter. Sometimes it happens. We put questions to elicit your skills, skill levels. Which books you have put your hands on? Which judgments you have seen? How you have grasped the ratio decidendi of judgments? There are theories. Professor Wambach's test, which the 12th edition of Salmond, Fitzgerald's edition, so beautifully is given. How you are going to derive the ratio decidendi of a judgment? There are tests, Wambach's test, which you call as inversion test. There is Dr. Upendra Bakshi test. You're just reading one paragraph and saying, this is the ratio decidendi of a case will not be sufficient. Briefly, you have to state what is the foundational fact matrix of the case. Then, what is the principle the judges have applied to that fact matrix? Then, that becomes the ratio decidendi of a decision. The famous case, you know that, Quinn versus Latham, 1901, Lord Halsbury's judgment. Quinn, Quinn, Latham, Leathem. One of the famous judgments, very often the seasoned lawyers put across, and some judges also refer to. What is that ratio decidendi? The ratio of a case is the principle laid down in a given fact matrix and not which is logically derivable from what has been laid down. The famous book on Rupert Cross's Precedent in English Law. There is Indian version, Professor Lakshmi Kanta, on Precedent in Indian Law, on par with like Amartya Sen's idea of justice, John Rawls' theory of justice. That way it is written. But Precedent in English Law by Rupert Cross is a classic book. 2. 3. You should have laid your hands on some good authors, because you want to impress the court and get an order in your favor. How are you going to impress? By singing, dancing? No, law does not permit it. Courts also will not. Although in one Rigveda there is a shloka where it said, in front of Devagana, a saint argued, Adhivakta in Sanskrit, Adhivakta argued in Panchama, Sarya Padani, in Panchama Swara, and very elegantly and with good demeanor. There is such a shloka in Rigveda. But that is now it's not allowed. But that being said, we judges are human beings. So poetry, beautiful prose, they impress the human minds. Is it not? Literature. In one case, which Daptari was arguing about the prohibition, total prohibition in state of Bombay, when Morarji Desai was chief minister. Then Supreme Court asked him, Mr. Daptari, wine is a bad thing. Therefore, Bombay government has made law prohibiting, bringing total prohibition. Then Daptari said, my lord, it is John Keats who said, give me woman, wine and snuff, till I cry hold enough. You may do so sans objection, till the last cry comes from the heaven. Then judges started listening. Poetry impresses the human mind. That is the reason why most of the scriptures are poetic. Take Quran from Islam. Take Old Testament, New Testament from Christianity. Take Torah of Jews. Take Jhanda Avesta of Parsis. Take our Vedas, Ramayana, Mahabharata. All they are poetic because they impress the human mind. Therefore, let your language be not only truthful but beautiful also. Satyam Sundaram. If you want to address Shiva, well and good. Satyam Shivam Sundaram. Our movement should be from truth to beauty. Beauty impresses. That is the reason why Roman lawyers used to sing when they were arguing. Cicero's 12 tables are poetic in essence. Make use of that poetry. That you can do only when you read poetry, only when you read Shakespeare, Byron, Yeats, Keats, Yeats. Is it not? Dredon. Otherwise, how are you going to quote? So make best use of poetry in your argument. There are good books, law and literature and law, Shakespeare on law. At least 3 books I am quoting. Just see them. When a case relating to bribery, corruption charge was being argued, the lawyer said, my lord, Shakespeare says, even an honest honeysucker licks his fingers. See, when you say that, how mind of the judge opens, the fertility level goes up to hear what you are saying. Is it not? That way. Therefore, read the English poetry. If possible, Kannada poetry, Tamil poetry, Tirukkural, one of the finest books in Tamil, Tiruvallavars. Such books you should read. Only then you will be able to. In one case, a matter relating to a farmer, he was arguing that matter. Judge was from some urban city school of law. I will not name the lawyer, nor I will name the judge either. Then the lawyer said, "My lord, agriculture is the backbone of this country." But that judge had read Sarvajna's Vachanas, Tripadis, three-liners. Sarvajna mentioned about agriculture and agriculturists. There he said, "My lord, Sarvajna says, ಕೋಟಿ ವಿದ್ಯೆಗಳಲ್ಲಿ ಮೇಟಿ ವಿದ್ಯೆಯೇ ಮೇಲು, ಮೇಟಿ ಇಮ್ರಾಟಿ ನಡೆದುದಲ್ಲವೇ, ಲೋಕಕ್ಕೆ ಮೇಟಿಯೇ ಶ್ರೇಷ್ಠ ಸರ್ವಜ್ಞ." Judge granted stay because he was impressed by the Sarvajna Vachana than by law. So make use of these things. First thing is Art of Argument by Gerald. Many books are there. One of the famous books, an American trial lawyer has written that book, Art of Argument. How you stand before the judge. How is your demeanor? How judge is looking at me? How is my voice? How is my English language? Maybe Kannada language, Tamil language, local language, Bengali language. Okay. If you do not know how you should present yourselves, then beauty is lost. Therefore, know these things. Number one. Number two, it was Osho who said, pause is part of speech. Pause is part of speech. When you are arguing, what is that you want to do? You are addressing the human mind. When you pause, the listener starts applying his mind to what you have said. You should allow the listener to process your speech. That is argument. That happens when you maintain pause between two sentences. Otherwise, you rob off that liberty of your listener. So think what you want to achieve. Which in I am okay, you are okay. Dr. Thomas Harris, one of the best books, is the transaction which you intend will not happen. Because the parties to transaction do not have id idem. The meeting of mind is not happening. That you have to ascertain. If judge is asking a question, my lords, please tell me, I am here to make an effort to answer. It's not that every question I will be able to answer. Even Socrates could not answer some of the questions which were put to him by his disciples after he consumed hemlock. And hemlock was not the reason. Socrates said, I do not know. People say I know everything, but I do not know. I know only one thing, that is I do not know anything. That was the position of Socrates. Therefore, when judge asks a question to you, be patient to him, be inquisitive to him. I am happy that you are asking this question. I may not be able to answer, but I am very pleased with this question. You cannot say it in so many words, that would sound very verbose, but give that impression to the judge. The best of the books on advocacy, they say like this. There is one Chandrasekhara Iyer, The 7 Lamps of Advocacy. One of the best books which you can refer to. Number 2. So, you did not quote poetry. When it was a matter relating to tax, you could have quoted Raghuvamsha by Kalidasa. You could have quoted Arthashastra of Chanakya. Chanakya says, the king should collect the tax in such a way that a honey bee would collect the nectar from the flower without stinging its petals. Therefore, my lord, it is not that I want to escape taxation. I will pay, but I am entitled to plan tax planning, which my brother was mentioning. Tax planning and tax avoidance, tax evasion, they are beautiful concepts. That you could have said. But it's a matter relating to tax. That way. And one of the Mooters answered our question so beautifully. Difference between tax and fee. That Sanjeeva Coke versus Union of India. I think 83 or 84 Supreme Court. So beautifully they have mentioned what is tax, what is fee, what is penalty, what is charge, what is levy, what is fine, and what is gratis. These things you have to know these things. Give wider scope, have a wider canvas. That helps you. And you, again I should say that you argued so well that you looked at the seasoned lawyers. But both the lawyers cannot win the case. One of them has to win the, unless compromise is entered into. And we are a tribunal, therefore we cannot record a compromise. The tribunal, civil courts can do it. Ordinarily, the tribunals being the creatures of statutes, they have to work within the four corners of the statutes. Ordinarily, they don't have inherent power unless law recognizes or grants such power. I am not very sure. I am not from the tax domain. Perhaps Raghuraman would be able to answer that question. Maybe the Moot question for structurer, he also may answer that question. That one. That somebody used the inherent power, something like that. Some rough idea you could have given that. Other person mentioned instrument. Like talak, thrice he uttered that one. But what is the difference between instrument and document? What is the difference between transaction, instrument and document? The Karnataka Stamp Act 1957, and even Indian Stamp Act, speaks of instrument, whereas Registration Act 1908 speaks of document. Document is not defined in the Registration Act, but it is defined in Evidence Act. What is a document? A stone was considered to be a document. A privileged will, where the soldier, combating soldier at the battlefield, writes something on the ground itself, that was considered to be a document, and bequest was given effect to by English courts, which if a German on Wills will mention, the famous author, German on Wills, he has mentioned about this. Why this difference? It is not that the parliament or legislatures do not understand language. Most of the times they understand. Rarely they do not understand. Therefore, we interpret the law. Some elaboration was required in that regard. You assumed that we judges know. At least this judge did not know. You could have assumed that way. Therefore, do not assume and proceed. That already they know everything. It is not that Halsbury's come here and sit as judges in our courts. Lord Halsbury does not come. Our judges are drawn from rural areas, from city areas also. Therefore, do not assume that these things are known to judges. Therefore, they need not be told these things at all. But it was a great experience to us, a great learning, and it was an honor to sit in the midst of the great people, the domain experts. I felt I am returning home with some extra load, value addition, which I made. In fact, Sarvajnanembuvanu garvadindadavane sarvaralonnondu nudigalitu ವಿದ್ಯದ ಪರ್ವತವೇ ಆದ ಸರ್ವಜ್ಞ. ಥ್ಯಾಂಕ್ ಯು so much.
Thank you, Your Lordship, for your words of wisdom and for the valuable insights you shared with us. May I now invite the guest of honor, Sri Raghuraman V, to address the gathering.
The most difficult part of this speech is following Justice Dikshit. No one can match him in his oratorial skills and knowledge. Probably. I know that the people who are sitting here will know the truth in my lies. You see, I have had the privilege and fortune of appearing up at least before 12 high courts, apart from the Supreme Court. And I can confidently tell you that you are lucky to be seeing the best judge in the country today. Why do I say that? You've got a glimpse of his knowledge, starting right from Vedas to Quran, right up to philosophy of law, philosophy, history of law, philosophy of religion, poetry. You can't match him in this. See his court hall also. See, there is no prepared text. It comes by itself. That is how Saraswati works. We all went to Kumbh. Many people went to Kumbh. Ganga and Yamuna and Saraswati is supposed to be hidden. Why is it hidden? See, in our yoga, your left nose is Ganges and your right nose is Yamuna. And your Sushumna Nadi is Saraswati. Where true knowledge lies, that is where it lies with him. True knowledge. I may be the left or right nose, but he is the Saraswati. Coming to the Moot court today, I can tell you I second whatever he said. We asked so many questions just to see if the participants will be flustered. Are they going to break down? It never happened. All the four of them withstood our questions. In fact, the respondent side, we actually barraged them with questions. We made their life miserable, as they may say. But they withstood it. Withstood and answered. Which to our mind, we felt that all these four people have worked very hard to come to the finals. And they have put in a fabulous performance. They have done their research to the extent that they have studied. And more than that, art of advocacy is also art of withstanding what the judge will do on that particular day. One day he may be soft with you, and the other day quite hard because he feels you're not up to the mark on something. You should be in a position to withstand. After all, like you, he is also a human being. That I found in all the four of you, and we were all agreed that all the four of you were outstanding in that respect. Knowledge, if you take tax and corporate law, is a niche area, seldom practiced. Of 100 advocates who come out, maybe 3 or 4 may actually think of practicing tax law. And that is where I found that these boys are, you must be in the first, second year or maybe third year. Probably tax was not a subject also, as yet. Corporate law. A mix of all this put together, this question was a tricky question. It was not a very easy question. I found that the application of mind of the 4 of these students was exceptional. They were able to narrow in on the points and also go into the statute and to the extent possible and point out what were the possible pleas that could be taken. And they, I think, took, at a student level, if they have taken 70 or 80% of all the pleas that we can probably think of, I would say it is exceptional. And I think these 4 boys did it. What does this actually reflect? This reflects that law education has come to a situation where young boys of 20 or 21, as Justice mentioned, are probably better than the tax lawyers of 45 and 50 today. So imagine if some of these boys were to take tax law, by 30 they will be equal to some of us who are nearing 60. And that is a great advantage to the courts. The reason being, these are the people who are going to teach the courts what is tax law. And this kind of exposure which these boys are getting, which probably we never dreamt of, by way of moot courts, by way of exposure to actual persons who are dealing with the law, those who decide cases, I think is something which is to be praised in the way the legal education has gone about in this country. I should also, I think, thank the Surana and Surana who have done a fabulous job. They have set questions on corporate law and taxation in a niche area, rather than the constitutional, civil and criminal law which all of you will deal with as it is. It's a unique proposition. And Mr. Karthik was set a wonderful question. The JSS institution also, I think I should place on record my appreciation for the way they have conducted this program, the way they have gone about this, calling one of the best judges in the country to preside over it. In a nutshell, I don't want to speak more than this. In a nutshell, I would say that this Sunday has been spent very productively. And more than us teaching you anything, I have learned the art of advocacy from these 4 people. Thank you very much.
Thank you, sir, for sharing your insights. I now invite Shri Preetham Surana, Partner, Dispute Resolution and Head Academic Initiatives, Surana and Surana International Attorneys, Chennai, to address the gathering.
My cordial compliments to dignitaries on the dais, off the dais, respected faculty members, scholars, staff, student conveners, faculty conveners, Moot Court committee members, students of JSS Law College, media persons, and my dear participants. It is my privilege and honor to stand before you and before this dignitaries representing our law firm, Surana and Surana. Our law firm has endeavored to build an ecosystem of immersive and experiential learning through the Moot Courts in the country nearly 3 decades ago, which is now the world's largest Moot Court program. We have provided opportunities through our academic initiatives platform, organizing and conducting essay competitions, judgment writing, and arbitral award competitions, besides others. During our deliberations with members of the bar, bench, and academia, the following aspects, 4 aspects in particular, have come forth, which the fraternity feels will be something relevant in the present and the future. One is the simplification of language and use of anecdotes for effective written and oral communication. Second is a mindset of conflict management and resolution required, that is to present legally and practically acceptable solutions. Third is to promote the use of technology in law practice and adjudication. And last but not the least, a thrust on policy advocacy for greater awareness, original thinking, and leadership development. So these are the 4 broad criteria. I have spoken about this earlier a number of times, but today I stand before you to share one of the implementation points which we from the Academic Initiatives platform at Surana and Surana are experimenting with. We have started this experiment. The background is, in today's digital age, technology is revolutionizing every aspect of our lives. However, our legal framework are struggling to keep pace. As we navigate the complexities of artificial intelligence, blockchain, cryptocurrency, cybersecurity, and more, it is clear that the law needs to evolve and address these new challenges. We felt there is a need to do something to address these issues of the digital age, and we need to do something to bridge this gap. To address this critical need, we have launched an innovative competition called Law and Policy in association with IIT Madras that brings together students of law and science to come and present and suggest probable solutions for the most pressing issues, which would be the intersection of technology and law. This initiative invites students from diverse backgrounds to collaborate think creatively, and propose innovative solutions to real world problems. By combining legal expertise with technical knowledge, participants will develop a better understanding of the complex relationships between technology and law. To stretch that, how it would impact society in which we live, there's an opportunity to cross-learn and help evolve policy through these measures, through innovation, critical thinking. This is an attempt, an experiment to see if these pressing issues could be addressed in our digital lives. This sharing of ideas and solutions to industry experts, policymakers, and academicians will contribute to the shaping of law. This academic year is the second year of this Tech Law Challenge. IIT Chennai every year hosts a festival called Shastra, where learning through various activities and events are organized based on a theme. Every year they have a theme, and last year the previous academic year, the theme was Ethical Challenge, and we released a problem statement in line with the DPDP Act, that is the Digital Personal Data Protection Act. And last January 25, the theme was Future Smart Cities, wherein the participants were given a problem statement wherein they shared the ideas to the expert committee by providing techno-legal solutions. The idea is that just like in the NCLT, you have a technical member and a judicial member, a subject expert and a member of the judiciary. A collaboration happens where subject experts on various areas of technology and students of law. So students of science and students of law can collaborate and present these techno-legal solutions. We look forward to the student community participate in this initiative in more numbers and get themselves involved, hopefully, in the development of jurisprudence. This is something which I wanted to share since we have already done 2 rounds for the last 2 years. It gives me a better confidence to bring it to your knowledge so that we could take this forward and further. Thank you for your patience to hearing me and giving this opportunity. I thank all the dignitaries on the dais, off the dais. Some of you have been here since yesterday, judging or in whatever roles you have played. From the law firm, I would like to place on record the involvement of the whole legal fraternity, whether it is the academicians or the members of the bench or bar, in contributing to this endeavor of our law firm. And thank you very much, and Jai Hind.
Andariki namaskara. That's all the Kannada I could pick up in 3 days. So we come from the eastern coast of the country. We are from NUJS Kolkata. Those are my 2 teammates over there. I'm originally from Odisha. So I have participated in Moot Court competitions before. I have been the part of the organizing committee. But this is something which will stay with me for a lifetime, not just as a competition, but as an experience of a lifetime. Because there's an element, whenever you go to a competition, you're mostly occupied with how will I win this? What do I get out of this? What's the prize money? What is the consideration? But for the first time when I came here, initially I was very occupied. How will I finish my compendium? How will I get my arguments vetted? How will I practice so much? But when we went to Suttur, beg your pardon, when we went to Suttur for the first time, the environment of the mutt over there, that was such a pleasant surprise for all of us. It calmed down all of us from the anxiety we had. And the atmosphere, that I had the best summer of my life over there, had the best asam of my life over there, and beyond that, everybody was so nice to us that made us believe in ourselves that we are here for a better purpose than just winning a competition. It was such a pleasure to argue before such an enlightened and esteemed bench. As an aspiring civil servant, and I saw so many police officers in the audience, this is one experience which I've never seen with any other moot court competition. So this has been an experience of a lifetime. For the first time, I can say this, that it doesn't matter whether I win or lose this competition, or my teammates also, I can say this on their behalf. We have taken so much in terms of learning from here, and this surely will leave an imprint on our future career decisions, on our outlook of law and career as a whole, on our outlook of this profession as a whole. So I thank all of you for organizing this event. I hope this continues to be organized further, and thank you so much. Dhanyavad.
Thank you. Can I have one more participant?
Good evening to everyone present here. Firstly, I cannot overstate how much of an honor it was arguing in front of this esteemed bench. I think I agree with my friend from NUJS, where he said that this is probably one of those times where we don't care about winning or losing. I was talking to my teammate as well. Normally we're very involved with the fact that did we win, did we lose, that type of thing. But from the moment I stood there, and when Sir put us with ease with regards to, he even put questions to the audience, and the kind of questions that came across, we felt that it felt right at home. It didn't feel like we were at a moot court competition. And I think that experience means a lot than winning in this stage. So thank you so much, sir, and thank you everyone for being here and judging us. Secondly, I would like to thank Surana and Surana as well for organizing this competition. I'm from Chennai, and so we know the kind of work Surana and Surana has been doing. And like for myself personally, I did my last internship with an IP firm, and all you hear in the IP field is Surana and Surana and the kind of great work they're doing. So thank you to you as well, sir. Finally, I would like to thank JSS College for taking such good care of us. Like he said, right from the accommodation to the food, to the fact that everything was on schedule. I think it was a fantastic experience. So thank you so much, and yeah, just thank you for making this such a great experience for me and my teammate. This is something we won't forget for a very long time. Thank you.
Thank you. Can we have one last participant to share your insights?
Greetings to the bench. A very good evening to everyone present here. First of all, it is an absolute honor and privilege to be speaking in front of so many expert professionals in the field and many more very, very competent participants that I have had an opportunity to interact with. I am Suhani Bajpai. I am from ILS Law College, Pune. And this was my first time representing the college in a national moot court competition, and the mooting experience is a lengthy one. There are internal qualifiers, then there is bidding of competitions. So we were allotted this competition only 10 days before the memo submission, and it was a very, very stressful period. In the train, we were highlighting the relevant parts of all the judgments that we had compiled in the compendium, and that made everyone around us so curious. Everyone was asking us questions ki aap kaun se exam ki tayari kar rahe ho, humko bhi batao, and everything. And it was when I specifically talk about the rounds, we came out of one round, and 5 minutes later we were in the another courtroom arguing a completely different side. So the entire framework of arguments that we have in our mind, that is there, but back of the mind what goes on is that how do I balance being persuasive enough and not seeming disrespectful to the bench? Will I be stating an argument for one side to another? So a lot of things go around, and that has been made easy for us because of all the judges that we had. And throughout the last 3 days that we have been here, we have been surrounded by amazing co-participants. And I specifically mentioned them as co-participants and not as competitors, because it was an extremely healthy competition. And I would like to specially mention one team which is completely a first-year team with exceptional oration skills. They were against us and we were just in awe of them. And I think what really matters at the end of the day is that you know that you gave your best and that a lot of opportunities are going to come forward. And I am going back. I am going back with a lot more than and I think my team will agree. We are going back with a lot more than what we had brought to the table, be it insights from the judges, be it connections, everything. And there are a lot of people that we have to be grateful for everything that has been provided to us, be it the competitors, the organizing committee, and everyone. And we will really be actively seeking for more such opportunities. And congratulations to all the participants and all the best to everyone. Thank you.
I call upon one last participant to share your experience.
Good evening all, and I'm really grateful to be part of this competition. The honorable panel here and all the people who have gathered here on a Sunday evening. And as your honorable lordships quoted that beauty impresses. So there are two things which have actually impressed me. So one of this reminds me of a very beautiful quote that my teacher taught me. That is from Bhagavad Gita, in which Krishna says Arjuna that karma nyevadhikaraste ma phaleshu kadachana. So this talks about the karma we have done. Now all of us might not have made to it final, but end of the day we know that how we have prepared and made it to finals. And I'm really grateful to my team. My team is sitting there at the end. We come from National Law University, Odisha, again from eastern part of the country. And we are really glad to see the diversity we have seen here. Now coming on to the second beautiful, impressive thing that I've seen here is the hospitality that we have seen with the organizing committee here. I have mentioned it to the organizing committee, and I'm very certain that I'll never forget the way they have treated us. The kind of like availability, they were always available, not just the volunteers, but also the faculty members. Like it felt very homely. It was like they were our own faculties. So that's all. And thank you and have a great evening.
Thank you, dear participants, for sharing your experience. The moment we have all been waiting for has finally arrived. It's time to announce the results of 22nd Surana and Surana National Corporate Law Moot Competition 2025. I request Mr. Johnson Christie, Manager, Special Projects, Surana and Surana International Attorneys, Chennai, to proceed with the announcement of results and declare the winners. Over to you, sir.
Increase on the dais and off the dais. It's my privilege and honor to be here in before of all of you to announce the results. To start off, let us begin with awarding the participation certificates, and I request Professor K. Suresh, Chief Executive, Mr. Preetham Surana, Partner Dispute Resolution and Head Academic Initiatives of Surana and Surana, and Dr. N. Vanishri, Principal JSS Law College, to come forward and distribute the participation certificates. We will go with the competition order. CL01, Sri Venkateshwara University Tirupati, Divakar and Jyoti Kumar. CL02, SRM School of Law, Chennai, Subrita NJ, Yashwant H and Bharat Kumar V. CL03, Dharmasashtra National Law University, Jabalpur, Saksham Tiwari, Ajay Chandravanshi and Karnwaj Singh Kakodia. CL04, Indian Law Society's Law College, Pune, Jigisha Bide, Suhani Bajpai and Sejwal Gavde. CL05, JSS Law College, Mysuru, a home team represented Amina Ahmadi, Wangmai Jernipudi and Renuka H. CL06, National Law Institute University, Bhopal, Ayush Verma, Padma Priya Pradhan and Muchkund. CL07, St. Joseph's College of Law, Bengaluru, Prashant P. Millan Martin. CL08, University Law College, Bengaluru, Priyanka KC, Riya Sahu, Meghna BL. CL09, School of Law, University of Mysuru, Abhisara BS, Rachna S, Sandeep VC. CL10, West Bengal National University of Juridical Sciences, Kolkata, Shaurya Kapoor, Omkar Patnaik, Rudrakash Chaudhary. CL11, Shanmuga Arts, Science, Technology and Research Academy, Shastra deemed to be University, Tanjavur, Ramya Vijay Kumar, Tracy Nilofer and Padmavati KS. CL2, KIIT School of Law, Bhubaneswar, Odisha, Avni Agarwal, Aryan Dubey and Orin Datta. CL13, Gujarat National Law University, Gandhinagar, Paulta Tongsing Anal, Devu V and Aditi Mishra. CL14, National Law University, Odisha, Souvik Saha, Mutakwif Alam Khan and Sachin Dubey. CL15, the National University of Advanced Legal Studies, Novals, Kochi, Ansa Alexander, Fatima Nawaz, Irene Elsa Francis. CL16, OP Jindal Global University, Sonipet, Haryana, Arshita Girdhar, Chandana Sajja, Srinivasulu Gautam. CL17, Sarada Vilas Law College, Mysuru, Sanjana P, Neetu N and Jeevan. CL18, Vidya Vikas Institute of Legal Studies, Mysuru, Yashwant M. Gowda, Yashwant Gowda J, Nanjunda Nayaka. CL19, School of Law, Christ, deemed to be University, Bengaluru, Samrid S, Niranjan Subbu, MS. CL20, Symbiosis Law School, Hyderabad, Adish Vasudevan, Borra Bharat Krishna, V. Ragul Krishna. Thank you, sir. Thank you, madam. Now we are going to move to the award categories, and I request Sri Parmeshwar Gowda P, Joint Commissioner GST Mysuru, to come forward. Please. The participants will come there, sir. They'll come up to you, sir. The fourth Best Memorial Award goes to CL02, SRM School of Law, Chennai, Subarita Yashwant H. and Bharat Kumar V. In this occasion, I would also mention about the fourth best memorial award being shared by one of the team who couldn't participate, but they submitted their memorials and they are equally sharing the fourth best memorial award are TC20, Savita School of Law, Saimach, Chennai, Tejashwi Satish Kumar, Shrikant Kemka, who are not available to join us today. The third best memorial award goes to CL15, the National University of Advanced Legal Studies, Novas, Kochi, Ansa Alexander, Fatima Nawaz, Erin Elsa Francis. The fourth Best Student Advocate Award goes to CL02, SRM School of Law, Chennai, Subrita N.J. And the third Best Student Advocate Award goes to CL16, Arshita Girdhar of OP Jindal Global University, Sonipet, Haryana. So thank you, sir. Now I request Sri V. Raghuraman, Senior Advocate, Bengaluru, to honor the awards. The team placed fourth in this competition are CL16, OP Jindal Global University, Sonipet, Haryana, Arshita Giridhar, Chandana Saja, Srinivasulu Gautam. The second Best Student Advocate Award also has a cash prize of rupees 5,000, goes to CL11, Tracy Nilofer of Shastra Deemed University, Tanjavur. The second Best Memorial Award also has a cash prize of rupees 5,000, goes to CL06, National Law Institute University, Bhopal, Ayush Verma, Padma Priya Pradhan and Muchkund. And the team placed third in this competition are CL14, National Law University, Odisha, Souvik Saha, Mutakwif Alam Khan and Sachin Dubey. Sir, thank you very much, sir. Now I request our Honorable Mr. Justice Krishna Dixit, Judge, High Court of Karnataka, to honor the Dignity Awards. The Best Student Advocate Award also has a cash prize of rupees 10,000, goes to CL11, Ramya Vijay Kumar of Shastra Deemed University, Tanjavur. I request Ramya to stay back. The Best Memorial Award also has a cash prize of rupees 10,000, goes to CL11, Shastra Deemed University, Ramya Vijay Kumar, Tracy Nilofer and Padmavati. And now comes the big announcements. During his speech, Sri Raghuram sir had pointed a note whether the students were from the second or third year. Let me inform that all the 5 students were from the second year out of the 5-year syllabus. Shall we announce the winning team? We'll go for a countdown. 5, 3, 5, 4, 3, 2, 1. And the winners are CL 19 School of Law, Christ Deemed to be University, Samred and Niranjan Subbu. The winning team also get a cash prize of rupees 30,000. The runner-up award goes to CL 10 West Bengal National University of Juridical Sciences, Kolkata, Shaurya Kapoor, Omkar Patnaik and Rudrakash Chaudhary. They also get a cash prize of rupees 15,000. The Best Speaker of Finals. The Best Speaker of Finals award goes to CL 10 Shaurya Kapoor of West Bengal National University of Juridical Sciences, Kolkata. Thank you, Honorable Judge and the dignitaries. Thank you, sir. Sir, there are 2 more awards to be given, sir. Sir. May I request Mr. Pritam Surana, Professor K. Suresh and Dr. N. Vanishi, the principal, to honor the Spirit of Surana Award to CL 17 Sarada Vilas Law College, Mysuru, Sanjana P. Neetu N. and Jeevan. The Spirit of Surana Award is honored based upon the team's nomination on their excellence of intellect and astuteness in augmentation, spirited and healthy competition, team solidarity, and goodwill and harmony with other teams. 2 hours.
One we have given 50.
Okay.
Winners team we are not given.
Okay.
Then rest to 10, 10, 5, 5.
Okay.
Just announce.
Okay. Uh,
Only 15 minutes.
okay. I would request the winning team CL19 to come forward and collect the cash prize. Rupees 30,000. I request Honorable Justice to hand over the cash prize.
Then 10 we have 1, 2, 10.
Best Memorial. Best Memorial Award cash prize rupees 10,000 goes to CL11 Shastra Deemed University. Please come forward. Ramya Vijay Kumar, you may also collect your Best Student Advocate Award cash prize of rupees 10,000, CL11 Shastra Deemed University. The second Best Memorial Award cash prize of rupees 5,000, CL06 NLIU Bhopal. Please come forward. Ayush Verma, Padma Priya Pradhan and Muchkun. And the second Best Student Advocate Award cash prize rupees 5,000, CL11 goes to Tracy Nilofer of Shastra Deemed University. Please come forward. I request Mr. Preetham Surana to come forward. A special appreciation certificate from Surana and Surana International Attorneys to the host university, JSS Law College, Mysuru. I invite Professor Mr. K. S. Suresh, Chief Executive, JSS Law College, Dr. N. Vanishri, Principal, JSS Law College, and Sri P. Nagendra Murthy, Associate Professor and Faculty Coordinator, Moot Court Association, JSS Law College, and all the members of the Moot Court Association to come forward. The Moot Court Association members and the student coordinators, please come forward. Come. Yes. I am also pleased to invite members of the home team CL05, Amina, Amadi, Wangmai, Jannapudi and Renuka to also join. A special mention and appreciation goes to Amina Amadi, who secured 5th position according to the top individual scores in the preliminary rounds, who qualify for the Best Student Advocate Award. Come up. A special mention and reminder to the participants. As mentioned during the orientation, please submit your judgment writing submissions for evaluations and award category submissions. You are requested to submit your judgment writing submissions as mentioned tomorrow 11:59 p.m. Please don't forget, the OC members will be with you to follow up and collect your submissions. In this occasion, on behalf of Surana and Surana International Attorneys, we thank the entire JSS Law College team right from the Chief Executive, Mr. K.S. Suresh, the Principal, Dr. Vanishri, Mr. Nagendra Murthy, Associate Professor and Faculty Coordinator, and all the organizing team and participants for hosting another well-organized Moot Court competition 2024-25. And we could see the students and the participants giving feedbacks. We would request that you may also send your feedbacks to the Surana and Surana LinkedIn page, and also email your feedbacks to mootcourt.jsslc.mysuru@gmail.com and ai@lawindia.com. Thank you. Thank you, the dignitaries on the dais and off the dais. Thank you.
Please take your seats. Thank you, sir, for announcing the results. A hearty congratulations to all the winners and the participants. I now request Professor K.S. Suresh, Chief Executive, JSS Law College, to felicitate Honorable Mr. Justice Krishna Dikshit, Judge, High Court of Karnataka. Your Lordship. Thank you, sir. I now request Professor M.P. Nagendra Murthy to felicitate Shri V. Raghuraman, Senior Advocate, Bangalore. Please accept our honors, sir. Thank you, sir. I request you to felicitate Shri Parameshwar Gowda. Thank you, sir. I request you to felicitate Shri Preetham Surana. Thank you, sir. I request you to felicitate Professor K.S. Suresh, our Chief Executive. Thank you, sir. I request you to felicitate Shri Achyuta. Thank you, sir. I request Professor M.C. Usharani to felicitate our Principal, Dr. N. Vanishri. Thank you, ma'am. I request Professor M.P. Nagendra Murthy to felicitate Shri Karthik Ranganathan. I request you to come on the stage and receive the honors, sir. Sir, I also request you to felicitate Mr. Johnson Christie. I request you to come and receive our honors, sir. Thank you, sir. I now request our Chief Executive, Professor K. Suresh, to felicitate Professor M.P. Nagendra Murthy, who has been instrumental in organizing this competition from the past 14 years. His tireless efforts and dedication have been instrumental in shaping this event into what it is today. Sir, it's our honor to recognize your contribution, and I kindly request you to receive the honors. Thank you all. I now invite Shri Pranav Kumar Nair, Assistant Professor, JSS Law College, to express our gratitude and propose vote of thanks.
A very good evening to one and all present here. It gives me immense pleasure to propose the vote of thanks. At the outset, I wholeheartedly thank the chief guest of the day, Honorable Mr. Justice Krishna S. Dikshit, a foremost jurist and a judge of the High Court of Karnataka, Bangalore, for graciously presiding over the event. Thank you, Your Lordship. I thank Shri V. Raghuraman, distinguished senior advocate and guest of honor, for his valuable diction and enthusiastic participation. Thank you, sir. I also thank Shri Parameshwar Gowda P., Joint Commissioner of the GST, Mysuru, for his valuable presence and participation. Thank you, sir. My special thanks to Shri Preetam Surana, a bold visionary, advocate, and head of academic initiatives of Surana Surana, in making this event a grand success. Thank you, sir. I profusely thank our beloved Chief Executive, Professor K.S. Suresh, for his invaluable support and guidance to conduct great events like this. Thank you, sir. I thank Shri Karthik Ranganathan, sir, the author of The Moot Problem, and Shri Johnson Christie, SPM of Surana Surana, for their management of this event. Thank you, sirs. Many thanks to our beloved principal, Dr. N. Vanishri, and the coordinator of this event, Shri Nagendra Murthy, sir, and his entire team of volunteers for their hard work, without which conducting this competition would have been almost impossible. Thank you, sir. I thank Shri Achyuta, Chartered Accountant, Mysuru, for judging the competition throughout, from the preliminary round to the final round. Thank you, sir. My congratulations and thanks to the winners and runners-up and all the participants of this competition. I finally thank the distinguished invitees, media friends, teaching and non-teaching staff, and students for your valuable presence. Thank you all. May I now request everyone to please rise up for the national anthem.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
I request everybody to kindly wait till the dignitaries leave, and later please join us for dinner. Thank you.